Are these new seats up here?
I
Testing, testing, testing.
don't.
morning. This is case number 9703, Potomac Electric Power Company's Streetlights. For those that don't know me, I am Fred Hoover, the new chair of the Maryland Public Service Commission. And actually,
Bonnie Setchman, I'm a new commissioner.
yeah. And Commissioner Richard, I'm sure all of you know, and
Commissioner Barvey, I've been here for about 25 days.
so we have three new faces. So with that, why don't we take appearances? Who wants to start?
Good morning, Mr. Chairman, Commissioners Barvey, Suchman, and Chairman Hoover. Nice to meet you. My name is Douglas E. Keel. I'm an attorney for Potomac Electric Power Company, and I'm appearing today on behalf of Potomac Electric Power Company. Also with me are Ann Gwal, Gwal, and she is also with Potomac Electric Power Company. And we have our outside counsel here today, Mr. Thomas B. McGee of the firm of Keller and Heckman in Washington, D.C. They are the contract attorneys who generally handle contracts and these type of agreements for PHI and the PHI companies. I'm the regulatory lawyer. With that, I have one preliminary
Well,
statement.
actually, let me
Go ahead.
get the other appearances, and then we'll come back to you. So,
Good morning. My name is Sue Ellen Ferguson. I'm here on behalf of the municipalities. And with me today in support are the city managers from College Park, the village manager from Chevy Chase Village, and a representative from the city of Gaithersburg.
and just so going forward, do you have a particular way that you would like us to refer to your clients?
I think just generally we've been referring it to them as the municipalities, but it's really local governments.
No, I
because-
understand, but I just
Yeah.
want to, so when we say the municipalities, you
Mhm.
understand that we're talking about you and your clients. Okay.
Oh,
Thanks.
well.
Good morning, Chair Hoover and Commissioners. James Greger on behalf of staff. I would also like to enter the appearances of Michael Dean and Lloyd Spivak.
Okay. So,
Mr. Chairman, I have a question for the municipalities representative, just to understand who precisely they represent, if that's okay.
sure.
You don't represent MML. You just represent a few municipalities, the ones you mentioned, or
There are 7, to my recollection. I haven't counted them up.
Okay.
But in the beginning, this was taken as and I know I'm going back into history a little bit,
Mhm.
but this started out as a tariff proceeding, and some of the municipalities became participants in that. And then, at the direction of the commission, we attempted to put together a sales agreement, a template sales agreement, and a
Right.
template attachment agreement. And as part of that, Pepco reached out to pretty much all of the municipalities who have at various times participated, come to listen.
okay. So, but you're not representing the organization, the Maryland Municipal
No,
League.
no, this
Okay.
is, no.
Okay, thank you.
Mr. Mike Keel, you said you had a couple preliminary items.
Yes, I just had one opening item. It came to my attention yesterday afternoon that there was a computer glitch and the municipalities were not served with our reply brief. As soon as I found out, I called Ms. Ferguson to see if she did get the reply brief. She didn't. I provided it to her. Obviously, it was a mistake, and if they need more time, I understand that. Apologize.
Ms. Ferguson.
I would like to respond to that. As Mr. McKeel said, I was not aware of the fact that a reply brief had been filed by Pepco until yesterday afternoon. Attached to that is such voluminous material. It's like 300 plus pages. And I've had a quick run through there, and it appears that all but about 12 pages of it is transcripts of testimony from George Woodbury. Mr. Woodbury is someone who has, on a volunteer pro bono basis, helped out on the municipal side. He helps to run many of the systems in Rhode Island and Massachusetts. And so for the municipalities in particular, but I think also for both sides. He provided some invaluable information concerning the actual operational issues that have come up in the last 10 years that he's been working on this, and he's been working in the area for 20 years. And so I did not object when certain testimony from Mr. Woodbury and references to things he has said in our conversations were brought up. I brought some of those up myself because it was something that everybody heard at the time and had the opportunity to discuss. What's been attached now in a support of some of the arguments that Pepco is making is Mr. Woodbury's testimony in other proceedings entirely in other states that may or may not have had consistent issues with Maryland's law or Maryland's experience so far, and also are dated. I had a very quick opportunity to talk to Mr. Woodbury last night. He had not had any opportunity to see this because we just got it yesterday afternoon. So my first request is that the additional information that is attempted to be put in the record here, which is trying to be put in as kind of almost like a cross-exam or a way to call into question what Mr. Woodbury has said as part of our conversations, which is really an evidentiary type of thing. I've never really seen something like this happen at this level where we're really talking about not a record, but an agreed set of what happened. And all of these meetings were taped by Pepco. Everyone had an opportunity to talk to Mr. Woodbury when we were there. The information is available to everyone, including the commission, as to all of that. So now to put in what I've considered to be irrelevant to this case information, hundreds of pages of it, is, for one thing, inappropriate. It's not a reply. It's not a new issue that came up. If it was something that should have been discussed, it should have been discussed in the main brief, frankly. There's nothing new that it's replying to. And then we would have had an opportunity to reply to that, which we haven't had. And then the second thing is it's irrelevant. It comes from it tries to bring in other states, other cases where we don't know what all the issues were and whether or not it's being taken in context or out. And I haven't had the opportunity to even look at it closely. I can just kind of see what it is. So A, it's inappropriate to do this, and it should be stricken. And B, if in fact this commission is going to consider this information in any way, shape, or form in terms of support for Pepco's arguments here, then I am at a great disadvantage. It should have been brought up in the main brief. It's not as if a new issue came up. It's dead on the issues that were presented to this commission from the very beginning. And I haven't even had a chance, frankly, to go into it except to take a really quick review because I spent my day yesterday getting ready for what I understood would be in front of you today and that I would be arguing to. So those are my two issues with this reply, and I request that you strike it, the information that's attached. It's inappropriate that it come in now, and it's not a reply, it's the main case.
Mr. McKeel.
First of all, I think it is the information attached is all public information. There is only one piece of sworn testimony of Mr. Woodbury that was presented in a Rhode Island docket number 4442. It has direct bearing on this issue, and the information that we've attached to our reply brief is specifically related to issues that were raised in the municipality's initial brief. And I can't look at a crystal ball to see what they're going to say in their initial brief. The other information is, again, tariffs that have been approved by various commissions. There are draft bills of sale that were approved by other commissions. There's Mr. Woodbury's pre-filed testimony before the Maryland Economic Matters Committee. Again, that's sworn testimony. Then,
Mr. Chairman, can I comment on that? Are you saying that your testimony before the Economic Matters Committee was sworn?
I assume it's
No,
sworn
it's not.
testimony.
It's
I-
not.
I don't practice before the
No, it's not.
legislature.
It isn't.
Okay, well, there's pre-filed testimony, and then there is testimony from Rhode Island docket 442 from Narragansett electric officials and transcripts from those officials that go directly to the issue of how the mass plant calculation is done in Rhode Island, and that was raised for the first time in the initial brief, and the municipality said that Mr. Woodbury said everywhere it's done on a specific, unique basis. And for example, the testimony of Ms. Lloyd says this system can provide an accurate value of all lighting assets and service. However, this system cannot determine the location and value associated with any individual light. So it's directly in response to their initial brief, and it's appropriate and it should not be stricken. The commission decided, and Ms. Ferguson asked for an oral argument on this. I think I'm entitled to provide information to support our position. And I think the commission should consider that information. The other big attachment is attachment Q, which again goes to the municipality's argument about net book value, and that's information that Mr. Woodbury provided to us that he asserted showed that they do the net book value calculation on an individual basis, and that information does not support that position, and it's appropriate testimony to be in our reply brief.
If I may respond?
Sure, go ahead.
Thank you. For one thing, the valuation of the equipment that will be purchased by the municipalities is specifically an issue in this case. It's in the questions. So, and the municipality's position has been from the beginning, as Mr. McKeel is well aware, that net book value should be purchase price less depreciation. Their issue is we don't keep it that way. We don't keep that information that way. The referring to, and I actually, when I looked at this reply yesterday, some of the wording in here actually starts evaluating. It says, Pepco has looked at this and can't really tell how this all came out, but find this to be good testimony. Pepco, somebody has done an evaluation of the testimony, and that's what they're using it for in this reply. Who?
The decisions of the Rhode Island Public Utility Commission in case 442, there is a report and order out there where they made a decision based on this testimony, and so that's a matter of public record. All of the things attached, with the exception of item Q, which is the information that Mr. Woodbury provided us, is in the public record and has been, it's in the public record. There's nothing hidden about that. And, we were directed at the outset of this case to look to the gold standard states that have the sale and purchase of streetlights. And those states were set out to be Rhode Island and Massachusetts, both by the municipalities and in the Maryland Energy Administration primer on this, that those were the two gold standards that we should look at. And so we went and we looked at those gold standard states. And one of the big issues here is how should net book value be determined? And I think we're entitled to show that net book value is determined in those states based on a mass plant procedure, not on the individual procedure. And this information has direct bearing on that issue.
Mr. Greger, do you have any thoughts on this? I know you don't have a dog in this fight, so to speak, but
No, but I would note that Pepco's reply testimony was filed in the docket, so that's where I accessed that. So I believe that was filed in a timely manner, available on the commission's website.
Mr. Chairman?
well, actually, so let me turn to the panel. Anyone have any questions?
I do.
Okay, go ahead.
Thank you. Just for the record, I represented Gaithersburg and Rockville for 32 years, and so I'm pretty familiar with the timelines in all of this. But I wonder if the council for the municipalities reminds the commission how long this has been before the Public Service Commission. Do you know?
The particular conversation about these two agreements,
I mean, how long has it been before the whole establishment of possible sales?
year and a half?
Year and a
Well,
half?
I'm sorry. This started over a year and a half ago.
Mhm.
And we have engaged in multiple meetings with, as the persons who continue to be on the
Okay.
commission know.
All right, thank you. The gentleman from Pepco, I've forgotten your name, pardon me. So Rhode Island has a population of 1 million people, which is smaller than Montgomery County, Maryland. Do you think a mass net book value calculation for a state like Rhode Island is really a good measure for a state like Maryland that has 6 million people?
Yes, and I think the focus there is the mass plant calculation for the determination of street lighting rates and street lighting rate design is a generally accepted practice across all of the utilities in America. If you're looking at Commonwealth Edison in New York City, they use the mass plant calculation. So I don't think it's appropriate to look at the populations of Montgomery County and or Maryland vis-a-vis the populations of Rhode Island. This is a specific issue about what is the appropriate use of mass plant for setting utility rates, and how are street lights dealt with across the nation for setting utility rates, and that's with a mass plant convention.
So let me ask this question. The mass plant calculation that you're proposing to use, is this only for the lights in the state of Maryland or for the entire Pepco region?
It would be for the Pepco region. It would be Pepco-specific mass plant calculation.
So you're including DC and Virginia?
No, Pepco, Maryland, sir.
Pepco, Maryland, okay.
No, we do not serve any territory in Virginia. That was sold
Oh, yeah.
probably 15 years
Yep,
ago.
you're right, my mistake.
And we would not use for, it is the books and records of mass plant for Pepco, Maryland.
Okay.
And that's all we're talking about. And you can look to our attachment I, where we set out.
No, you've answered my question, thank you. So, I presume, though, even if you have not been keeping track of your asset valuations by pole, by light itself individually, does Pepco actually have an inventory listing of where their lights are?
We do.
So you could tell me how many are in Gaithersburg versus Rockville?
We can.
Uh-huh. And for your accounting department, it's impossible to separate out the calculation for Gaithersburg?
So, no, we can say how many are in Gaithersburg,
Mhm.
but what we cannot do is, and what the municipalities are asking us to do is, let's say, for example, there are 1,000 lights in the city of Gaithersburg,
Mhm.
and those lights have been put up in various years, various vintages. We can't go to a pole because we use a mass plant convention in our plant accounting. We can't go to a pole and say, on that pole, that light was put up in 1988, and that light was put up in 1995. As we note in our briefs, do we have those paper records in storage somewhere? Yes, we do. But that would require us to go to storage, drag all those out, and page through all of those work orders to determine the specific vintage of the specific light.
If I may, I was cut off earlier, and I would like to finish what I was saying to make it clear. We are now talking about only my request that this reply brief be stricken in the attachments. I'm very ready, willing, and able to address these other issues about valuation, et cetera. However, one of the things I wanted to point out that's in this reply brief, a reference is made to various, to testimony. And Mr. Woodbury had been asked to provide Pepco with an example of a specific streetlight purchase. And he did, that used individual valuation. And he did. This is where Pepco says, Pepco has looked at this, and they don't think that that's actually what it says. And then they say, how this total net book value for the municipality was determined is not clear from the work papers. They're providing information that even they don't know how it was determined to support a theory that has been their theory since the beginning. This is not relevant and, frankly, not reliable. Even they say they don't know how it was arrived at.
Mr. Chairman?
Um,
Yeah, go
Commissioner.
Okay, so I'm new to this, but I am a lawyer. I am troubled by Ms. Ferguson's inability to be able to effectively respond to your reply brief because it wasn't served on her. It doesn't matter that it was in the record. It's not incumbent on her to be searching records to determine whether briefs were submitted. So I'm troubled that you don't have, this was posted, noticed that we were going to have a hearing today, and you were not able to effectively prepare based on the information in the reply brief. Mr. McKeel, would you be able to make your case today without the use of the reply brief?
I could make an attempt, Your Honor. I think that the information in the reply brief provides direct response to issues raised in their initial brief.
Well, can you just make that the case today without relying on what was contained in the so can you just make the arguments today without having to rely on a document that Ms. Ferguson was not able to effectively review? So in other words, do we need to rule on the question of striking the document, and can we just move on? So can we actually talk about the substance? You can make your case with the information contained in the reply brief, and then the commission doesn't have to rule on striking or not striking the reply brief.
So I just want to make sure I understand what you're asking, Commissioner. So the commission would not in any way, shape, or form look at our reply brief or rely on it?
I'm just asking you if to move this along, would you be able to make your case effectively? You can note the information. We can review it. Ms. Ferguson can review it later. But can you make your case without having to rely on the document itself, which Ms. Ferguson did not have time to review?
Yes, Your Honor. Obviously, I feel confident in the arguments that we also made in our initial brief.
Do you have any questions?
Maybe just for Ms. Ferguson, and I'm just scanning once again the filing. Does this just primarily go to the first of your 6 issues, just the valuation of the system, how the process we would go through the valuation process? Because we have discussed that in previous hearings, and I know it remains an issue. A lot of data, a lot of information has already been provided to the commission, and on that, yet this was some new information that was provided, but there's a lot of contextual issues. I was trying to figure out how this would, fit into our evaluation, since again, a lot of has already been provided on this. So maybe to my first question, does this just go to the valuation question, which was, I think, the first of your 6 issues?
I believe, from looking at this, that is what it goes to. And you're correct. There is a lot of information about there that's a lot closer to home, and we can take in context and know what that context is, such as we know we're working in Maryland and what is going on in Maryland, and maybe D.C. next to us. So that, I think, is what is. I can't swear to it because I haven't had a lot of time
Fair
to
enough,
look
yeah.
at it, but I believe that is what it goes to.
Yeah, and I intend to, I will support the ruling of the chair, but, I would hope that we can get as much done today as possible, and so if at a minimum we can get through the other, 5 items, would you agree that there might be some value there if we were, depending on what the decision is, we work on those other 5 items, or do you feel that you would still be disadvantaged by the filing and discussion on those other 5 items?
I think that the suggestion that possibly we have the opportunity afterward in writing to respond to what has been added in this reply brief might be helpful. We filed on time also. We copied everybody, and we're here and ready to go, although I lost time yesterday getting ready because I had to look at this other item. But we are prepared, and so we don't wish to hold this up. It's been going on for a very long time, and there are municipalities that have been interested for 15 years in acquiring their lights. So we don't want to get in the way of the progress of this case. But I wanted to note that just separately, we find this not in context, not relevant, and frankly, even they admit they can't really tell how it got the rate, not the rate, but the cost got calculated. So if the commission was going to rely upon that in any kind of way in making a determination on these issues, that is our concern, because we haven't had the
Well,
opportunity.
Mr. Chairman, with that information, I believe the intent was really to take everything we have today under advisement and not necessarily rule for the bench. I don't want to step on the prerogative of the chair to do otherwise, but, I would suggest that we try to do as much as we can today, and then perhaps, we can allow a later filing should there something, to transpire that would need correcting. So that would just be my thought. Thank you, Mr. Chairman.
So my concern, Mr. Markeel, is the fact that the reply brief wasn't served on the relevant party. And I guess in particular because, unlike a case that had multiple parties, there was only a couple. And so, and I'm not casting aspersions upon him, and I'm sure it was an honest mistake and all that sort of stuff, but I think it's a fairly significant mistake, and I think it does put the municipalities at a disadvantage. The other thing I'm concerned about is that Mr. Woodbury has been promoted, from what I've read of in this proceeding, as sort of the acknowledged expert in this area, and both the municipalities and Pepco have cited him to sort of support various things. So I'm a little concerned about having documents and that he's prepared and done without him being here to sort of explain nuances, differences as to what he said someplace and why it may not apply here. So I guess my concern is that if we, if he's an integral part of the discussion of these issues, but he's not here, I'm very hesitant to allow use of documents, even though they're public documents and they've been filed in other jurisdictions and things like that, to help make the arguments today. So I guess what I'm asking you is there a way for us to proceed forward on some of these issues that maybe Mr. Woodbury wasn't integral to the discussion of, and try to come to some conclusion on that, and then either have a follow-up proceeding or respond in writing, or is his testimony and expertise so intertwined into all these issues that we really can't make any progress today?
Mr. Chairman, I think we can make progress today. I'm prepared to talk about all of the issues set out in the brief, the 6 issues that are 6 or 7 issues that we have listed, and I'm prepared to go forward.
Well, but the other concern I have is I don't want to start down this road and then have multiple objections from the municipalities of going into and relying on information that was provided in the attachments to the reply brief.
Yep, I understand
So I guess my thought is either we, eliminate a couple of issues where he's the big piece of it and deal with that at some later point and then move forward on the others, or, do we just reschedule this at some later point? And I guess what I would look to is for, I guess, the 3 of you, if you can come to an agreed set of issues that we can talk about today that doesn't involve Mr. Woodbury, then we'll proceed ahead. Otherwise, maybe we need to rethink this.
If
Ms.
I
Berger?
may,
Sure. Mm-hmm.
these issues were all discussed in the first briefing. All of them. Mr. Woodbury is referenced there, and testimony that he has given before is referenced there too. And we have not objected to that because that had something to do with what we're doing here in this state. So the concern that I have is these extraneous other decisions in other places where we're only seeing Mr. Woodbury's testimony or pieces of it. I have no idea. There's another person whose testimony is quoted in here who's from Rhode Island as the basis for asking you to make a decision based on that. We have no idea what that context was either. It's not relevant. It's not useful. This decision is before you, and it's pretty straightforward, and it involves a couple of items: the valuation and whether there's a warranty, an as-is, where-is transfer, and the warranty. So what other places did 10 years ago, because that's when they did their work, when they did their laws, when they did their tariffs, sorry. And so if this additional information that is stuck onto this 300 pages of additional information that's stuck onto this reply brief. And I have frankly never seen a reply brief that much additional information. We are both working, unfortunately, where we don't have an evidentiary hearing below. Not unfortunately, that's just the fact. And so this record as it is, was developed over the course of many conversations between a group that had pretty much the same makeup. To bring in someone else's out-of-state testimony in another case entirely and try to insert that into the record at this time is trying to get, I don't know, it's attempting to add evidence. Not arguing evidence, it's adding evidence, which is inappropriate, both in the lateness and also in how the fact that this has not been an evidentiary matter. We have all shared information. We have all worked together to do this, and have this happen at the last minute was a surprise, but also inappropriate. We object to the additions that are made to the reply because it's the same issue all over again, but it's all new information that is being relied upon in parts. So that's what we had the objection to. I'm ready to go on all of these issues today, but you're correct. If anything comes up that's referenced in that reply brief, I would have to make an objection about it because, for the reasons I've stated.
Mr. Chairman, I'm sort of inclined to also strike it. I just, I'm not sure it's helpful, but to the extent we go through issues today, and within the context of those issues, a concern is that you've Mr. McKeel, you have a concern about a particular issue. I'm assuming we can accept after the hearing filings that can address certain issues, and to the extent that you would like to present anything in the attachments at that point that would give counsel for the municipalities an ability to respond, but would also be within the context of what we do today. So it may be that based on what we accomplish today, those attachments are not necessary, and the arguments raised in those are arguments you won't need to make. So, Mr. Chairman, we could just table this, and then decide at the end of the hearing.
All right, so I'm going to do this since I'm brand new at this. We're going to take a 10-minute recess and chat amongst ourselves and try to make a determination as to the path forward. 10 up. So, back on the record, we've had extensive discussions about the reply brief, and it is our decision to strike the reply brief and grant the motion by the municipalities. It's our concern that this, the substance of the issues involved in the information that's provided in the attachments and the key aspects that Mr. Woodbury played in earlier proceedings, puts the municipalities at too much of a disadvantage, given the fact that they did not receive this and haven't had any chance to really respond to it. So with that, we're going to proceed ahead. The process that we were going to use today was to let the municipalities speak on the issue first. Pepco will respond. If there's some need to respond to that, then the municipalities can respond to what Pepco says, and then obviously we'll turn to staff to make a any points they want to make on these issues. So,
And
Ms. Ferguson.
thank you. Do we have a time limit?
Well, let me put it this way. I'm not going to pose a strict time limit. I would like you to be concise, but make whatever arguments you think are necessary to. But keep in mind, we've actually read lots and lots of material on this, so you don't need to recite everything you've told us before. So.
Understood. Thank you. So, this morning we are here to discuss a part of the tariff issues, which is the sales agreement and the pole attachment agreement, which all realize are two items that have to be entered into between Pepco and any local government that wants to purchase. The state law, of course, requires Pepco to sell equipment if the municipality wishes to buy it. However, the state law does not guarantee attachment to the pole. And we recognize that from the very beginning and then looking at this tariff, and so asked the Public Service Commission to please make provision for that. It is something that MEA had also suggested in their review of streetlight status in Maryland. The PSC agreed to that, and that's what we have been doing now for months. We have all appreciated the participation by Pepco in this. They have put a lot of time and energy into this, as have the municipalities. And so we have, as you've seen in the filings, resolved a lot of issues that were contentious, and we're glad that that has occurred. Now there's not going to be any longer a pole attachment fee. The Pepco has recognized that the first thing that municipalities would want to do after acquiring the lights would be to change out the bulb, because they would like to go to LED as soon as possible to start their savings and help pay for all of this. And so they have agreed that a long process of application and inspections, et cetera, is not required for that, and that is in this agreement. And that allows the municipalities then to proceed as quickly as possible, because this is really no more of a burden on the pole. In fact, it's probably less. They've also recognized that dimmers are extremely important cells to be able to put on the equipment so that we can take advantage of use of lesser lighting. And also they've recognized that there's a big issue with municipalities and their equipment, because they are last off of a pole when it has to move or when things have to be relocated, and therefore initially this agreement attempted to put all the cost of removal of a pole or on the whoever's last off. The municipalities are always last off. They're the street light. And so that's been an issue that's been dealt with. So what we're down to now, and that's what Mr. Woodbury helped a lot with, is the operational issues. How is this really going to work? And he's been valuable for that purpose. So we're down to these issues about, the first one is whether or not the municipalities are required to buy this on an as-is, where-is basis.
I just want to interrupt you. So the way I would like this to work is, let's just talk about the as-is issue, and then we'll have Pepco respond to that and staff, and as opposed to like going down the whole list. So we're going to go issue by issue. I'm going to, the concern I have is that we, could go down a rabbit hole, but I will attempt to try to prevent that. But as you're going forward, just stop when you get to the end of the as-is discussion.
I was intending to do so. That was a little bit my opening that I'm not really going to be giving. So just to note that we have worked hard and gotten rid of some issues that were contentious. So this is just the one issue. And whether or not the municipalities have to buy on an as-is, where-is basis, and also whether or not, if that's the case, there should be some kind of warranty or warranty period for the municipalities. Pepco has argued that everybody else buys on an as-is, where-is basis, and they've referred to other jurisdictions for that. And all the other jurisdictions that are out there, and there aren't that many really, when we're talking about the golden ones, those are the ones that exist at all. This is still a thing that's happening in the United States that's not prevalent for municipalities, local governments to purchase their lights. So the ones that in the Northeast that Mr. Woodbury is familiar with all did their work 10 years ago at least. And Mr. Woodbury has said that due to his nonprofit organization that has been operating these systems over the last 10, 12 years, they've learned a lot about what works and what does not. And this as-is, where-is issue is one of those issues, because the wording, and that's still in flux what the wording is, because it's dependent on what you are going to say or decide, but the wording that they're seeking is the municipalities acquire an as-is, where-is basis, and then immediately are required to comply with all the safety requirements that are applicable. And they're listed in the brief, which are multiple, and there's good reasons for that. One of the things that we learned during the course of these discussions is that while Pepco does have a list of the equipment, the lighting, the street lights that they have in each jurisdiction separately, they don't have any other records that they say are accessible in any kind of other than burdensome way that tell you what's actually there, how long it's been there, whether it's ever been repaired. None of that information is available. They have explained that so when they say that their streetlights are living up to the specific requirements that apply for health and safety and hazards, that's a general statement that they have not don't specifically have any information to support, except for when complaints come in, they go out and they look at the street light. And there are other times when folks go out to take a look at them, but they don't know what was actually put there in the first place in any kind of way that can be provided to the municipalities. That's what they told us. At first, and I know Mr. McKeel's going to disagree with this, throughout these talks, they said they didn't have it at all because they base their rates, the rate setting, on mass plan. And have stated that's a way that's accepted in the industry. And it may or may not be. It may or may not be to use mass plant. Mass plant means they take an average. And so for years, everyone who pays for the cost for having streetlights has paid maybe more or less than they should because it's average in the rate. Municipalities such as Washington Grove or Chevy Chase Section 3 has lights that are so old, they're decades old, and they're not LEDs. They're lights that would no longer be put into these streetlights and haven't been either environmentally correct or an appropriate use of funds for years. And they're still there, high pressure sodium. And these municipalities still have those lights, as does most everyone else in Prince George's and Montgomery counties who hasn't specifically contacted Pepco and paid them to switch out lights. So rates are charged even though some of the lights are very, very old and some of them are new or newer. And that's the way the rates are charged. So those are the records that Pepco keeps to hand. They don't keep the particular records about what's on that pole to hand. And that's one of the problems here. So and Pepco in the past has been selling to third parties who want to use the poles for purposes other than the initial reason that Pepco has the right to be in a sovereign's territory for free, in the government's territory for free, which is to provide the electrical service. These are other services that are being provided now, and folks, third parties, private businesses, buy from Pepco, and Pepco has the upper hand on that and can say on what basis those parties are allowed to attach. The cities and towns, on the other hand, are the ones who own these rights of way and have allowed Pepco to be there and have worked around Pepco ever since electricity was provided to the masses. And on top of that, the state legislature has said, the municipalities, the local governments have a right to buy these. They have a right. And so Pepco cannot use the same approach, or should not be able to use the same approach to municipalities as it has to third-party attachers who don't need to be on there, because the other thing that's here is that municipalities who have a right to buy them are keeping on the pole a street light, which is absolutely necessary to health and safety, absolutely necessary to commerce. It's not someone else's 5G cell or any of those things. It's something that is required to be there. So the municipalities are in a separate category altogether, and they are being required to take on equipment that Pepco can say, at most, generally, we believe our equipment is safe and lives up to the standards that are applied, but we are going to require that you, as part of this agreement, not assume that, but make sure it's happening, and if you don't, we can end this agreement. So the municipalities, because the only way that they can actually determine what is on the pole is to do an inspection. And one of the questions is, well, then who has to pay for that? Who has to pay for that inspection? Since Pepco says the way it's kept its records in, I guess, boxes is so burdensome to find those records that it would be better, now that we know that they do have them, it would be better to just inspect on the pole, which takes a bucket truck. And then the question becomes, who has to pay for that? The municipalities, now this has come up in other jurisdictions, and the municipalities are aware of the fact of, Pepco's conundrum here. We understand it. So our position is, if you're going to require that we comply with the law and the regulations that apply to this equipment that can be hazardous, you should be handing us something that is compliant with that, and not hand it to us and say, well, it's where it is, we're not exactly sure, and it's what it is, we're not exactly sure about that, but it's on you now. And what they cite to in all of this is other agreements with third parties that they're in, and also to some other states who adopted, and we don't know what the context of all these things are, adopted these tariffs 10 years ago or more. So if in fact you decide that it's appropriate that they should be able to transfer as is, where is, then there should be a warranty for that. There should be a period of time that the municipalities have to go and take a look at these pieces of equipment to determine if, in fact, what people expected to be there is there or not. It doesn't have to be a long-term commitment. The municipalities are going to be going onto the poles once they procure these lights, hopefully quickly, to switch out the bulbs so that they become LED immediately. And we have done our best with Pepco to streamline that process so that it doesn't cost too much, and because it doesn't need to, and would happen quickly. So if in fact as is where is what you adopt, then please provide the warranty for a period of time, for 2 years, to give the municipalities the ability on their own to have a certified person go up on the polls as part of work that they're doing that provides them some benefit, which is to switch out the bulbs and be able to determine if there's any hazards up there, and if in fact those hazards were there and were there when Pepco transferred that equipment, then Pepco should pay for it. There's a concern throughout the briefs that the staff has filed, and the main concern, I think, from looking at it, is that ratepayers should not be paying for any extras that have to happen here and that are, quote, caused by the municipalities. The municipalities are not causing equipment not to be up to standard. They're just acquiring the equipment, and they know going forward they have to maintain that equipment and are not asking for any kind of lesser standard. But right here you're talking about, yes, you have ratepayers, you also have taxpayers, which you haven't had on the other side before. These are taxpayers that are going to be paying for that. And the maintenance of this equipment has been charged by Pepco for years and years in the O&M. That's what's supposed to be happening with that money, is maintenance. So, all told, the municipalities do not want to take on some obligations that it has no idea about what the extent of it is. And if we want to know, then we have to pay for an expensive inspection that Pepco says the municipality should have to pay for because they don't have the records. Or we have to accept where is as is. And I think that there is certainly a middle ground in that you could adopt that helps to ameliorate the issues that both sides have about this. Because Mr. Woodbury's experience has been, in one town, there was a very bad problem that got shifted over to them by the utility, where what was supposed to be there wasn't there at all, and they had used the wrong kind of wiring, so that expensive repairs had to be made. But that most of the time, the equipment had been in fairly good shape. In these other jurisdictions, it was Mr. Woodbury's experience too. Their records were there. They had them as part of their FERC filings. I know there's a lot of argument about whether they did or didn't, but FERC does require that you provide a basis for rates. And some utilities have actual records that they can pull up that show what's there, how long it's been there, and whether any repairs have been done there. Pepco does not do that because of its mass plant rate process it follows, but we're not talking about rates, and we're not asking you to change mass plant for rates. We're asking you to deal with the sale of the equipment to a government that Pepco is mandated to sell to. Thank you.
Mr. Mike Heel.
Yes, thank you, Mr. Chairman. I would just say, kind of broad overview, that I agree with Ms. Ferguson that we have, in a little bit of an opening, that we have agreed to a number of issues in good faith negotiations, and that these issues that remain are the few. So we've made very good progress on that note, and we've worked very closely with the municipalities and had fruitful discussions. I will now turn to the topic of where is as is, which is one of the 8 issues that we were unable to resolve. First of all, we have been told from the start that there are some gold standards that we should be following in terms of the purchase and sale of streetlights. And those gold standards have been the state of Massachusetts and the state of Rhode Island. The municipalities, when this started, said those were the states that we should look to. The Maryland Energy Administration, in its report on LED lighting, said those are the states that we should look to. And so Pepco, in providing these model agreements, looked to those two states to see what they do and what the standard practice is in those two states. And the standard practice in both of those states is that the sale of streetlights are on an as-is, where-is basis. As I point out in the initial brief on page 8, the City of East Providence case, the NSTAR made it very clear that in 2019 that all 23 sales of street lighting equipment in Rhode Island are on a as-is, where-is basis. Now, Ms. Ferguson argues that that is an old standard, that it came about in 2013, but the facts just don't bear that out. First of all, the as-is, where-is standard is enshrined in tariffs in the state of Massachusetts that were attached to our initial brief. For example, the Massachusetts Electric Company tariff that was approved in 2019 has the as-is, where-is language. The NSTAR Eversource tariff that was effective January 1 of 2020 has the as-is, where-is language. And the Fitchburg Gas and Electric tariff that was attached to our initial brief was approved in January 1 of 2023. And it all contains the as-is, where-is statement when there is the sale of overhead streetlights. Now, Ms. Ferguson says that we've had learnings since then, and Mr. Woodbury has had learnings. If that is true, and if those learnings were persuasive, as you know as a commission, those tariffs would have been challenged before those commissions, and the commissions would not have approved those tariffs as just and reasonable if there was a problem with the as-is, where-is part of the tariff. That didn't happen. In fact, as I point out in the initial brief, Mr. Woodbury made very clear that every sale he had been involved in has an as-is, where-is provision. And with the exception of one entity, it's not been a problem. So I think the state of Maryland should follow the gold standard of Massachusetts and Rhode Island and make the sales consistent with that as-is, where-is. Now, Pepco did not say it's take it or leave it, as-is, where-is. We said we would be willing to provide a warranty, but just like when you're purchasing a house, if you want that warranty, if the purchaser wants an inspection of the house, the purchaser should pay for that warranty. Customers, street lighting customers, should not pay for the work to get that warranty. Now, I just heard something new today in Ms. Ferguson's presentation that the municipalities are only seeking a 2-year warranty. That's not how it's been presented in any of our negotiations. It's been a warranty forever and ever. Secondly, as we point out, it's well-established regulatory principle, citing to the smart meter opt-out case and order number 86,200, that in regulatory proceedings, the cost causer should pay for the costs. In this case, but for the requirement to sell, Pepco wouldn't have to provide a warranty. So it's appropriate for the cost causer in that case, based on basic standard regulatory principles, to pay for that warranty. In their reply briefs, the municipals assert that the agreement that Pepco has referenced was without assistance by the other state PUCs and legislative protections. That's certainly not true. Mr. Woodbury testified before this commission that he was the individual who wrote the laws for a streetlight sale and purchase in Massachusetts. Mr. Woodbury testified, and it's in the initial brief, that he's been involved with every single sale and purchase of streetlights in Massachusetts and Rhode Island. And every single one of those has been in a where is, as is posture, not providing any sort of warranty. Pepco is willing to provide the warranty, but we believe that the cost causer should pay. I want to address this issue about whether or not Pepco's streetlights, when they were initially put on to the telephone poles or to the poles, whether they're owned by Verizon or Pepco, were in compliance with code. Each and every one of those streetlights put up on those poles was compliant with the National Electric Code when those streetlights were put up, as required by COMAR. The question is now, has anything happened to those? And before Pepco is willing to provide a warranty, Pepco needs to check to make sure that there hasn't been some rain, any sort of thing. Maybe there's an animal nesting in it. It is true that Pepco does do its maintenance work on its streetlights, and if it finds any issues on the streetlights that it does maintenance work, it corrects those issues. But Pepco does its streetlight maintenance on a 10-year basis based on grids of the streetlight, so we don't know if every streetlight, may or may not have an issue. And I think it is a reasonable regulatory position that the cost causer should pay. I would note that the MEA streetlight report notes that all the streetlights there were 29 streetlight sales in Rhode Island, and all of those sales were in an as-is, where-is basis. So the survey is appropriately paid for by the cost causer, and requiring the customers to pay or the remaining streetlight customers to pay is not good public policy.
Miss,
Ms. Ferguson, any response? Or?
You wish
Well, okay, all right. So we'll go with staff. So.
Yes, Mr. Chair. This might be a little repetitive, but staff's concern in this matter was the cost causation issue and socialization of costs to ratepayers. So just to clarify, the cost causer in this situation would be the municipality because they're the one initiating a sale or a transaction for sale of the streetlights to the municipality. So any incremental costs associated with preparing equipment or facilities for that sale would be directly caused by the municipality as the cost causer. So along those lines, the general ratepayer base of Pepco wouldn't be receiving any benefits for the streetlights or any remedial work conducted on the streetlights for a pending sale to the municipalities. It would be the municipalities' taxpayers that would be receiving the benefits of that transaction. Though we would also note that in existing rates and O&M rates, the repair of streetlights are covered. So staff is unsure whether or not this would even be an issue, depending on how many of these transactions are actually executed. So this is more of a theoretical concern than a possible realistic one. So that's all staff has, Your Honor.
Okay. Ms. Ferguson, you have response to either one.
Thank you. So I think that the body of administrative law that is being referred to here about being a cost causer doesn't really take into consideration the fact that these are sovereign governments that have been given the right to purchase the lights from Pepco. And in this particular case, I know that when we were in front of the PSC previously, we talked about the fact that when you look at the state of Maryland, the hot yellow lights are still in Prince George's and Montgomery counties because there has been minimal LED conversion. So this was seen as the low-hanging fruit. Let the municipalities buy their lights. Don't get in the way of it anymore. Reduce the barriers and allow these conversions. the municipalities are not causing a problem. They're not causing whether or not these lights have been appropriately maintained or not. That's already been paid for, the maintenance of those lights. The municipalities didn't cause the fact that Pepco doesn't have readily available records to know what's actually on a pole. And this is also a problem when it comes to the valuation of the lights. What the municipalities are doing is taking a reasonable step to ensure that an obligation, an unknown obligation, doesn't move to them under the guise of, well, if you really want to know what the condition is, you got to pay for it. You got to pay for it either in the warranty or you got to pay for it to go out there in the bucket truck. And I'm not exactly sure still what paying for the warranty means. Does it mean an inspection? Does it mean, I don't know, additional insurance? I'm not sure what that means from Pepco's side of it, or how much that would even cost. The problem is that it is one of taxpayer or ratepayer. Ratepayers have already paid for this. The taxpayers are also ratepayers. They paid for it too already. And the effect of these not getting a good piece of equipment or a system on the ratepayers generally is widely dispersed. The effect on Washington Grove, with its small number of lights, can be very large for something that they've already paid for once. The ratepayers have already paid for once. So that is the position of the local governments, is that since they've already paid for this, they're not causing anything. They're just trying to buy the lights as the state has mandated they should be able to do, and not take on an unknown liability in the process.
Okay, any questions?
I do. So let's step back a little and talk about what it is you're purchasing, the municipalities are purchasing, and what it is that you as municipalities expect to do with the lights. So let's assume you've purchased them, your Chevy Chase or Washington Grove. Talk to me about what it is that you will be doing to the existing infrastructure that's on the pole. Are you going to keep that infrastructure? Are you going to be replacing that infrastructure? So in other words, I'm asking, what is the value of what you're purchasing?
The value of what's being purchased now is the streetlight. That's it. There's the attachment to the pole is something different and involves all sorts of other obligations that can occur depending on whether there's going to be other attachments on the pole, if Pepco has needs.
No, but okay, so I'm talking about,
Right.
so the existing streetlight,
Yes.
that has value to you now, or is that something that's going to have to be replaced in order to put in the new LED lights, to make it more efficient?
And that is a complicated question, maybe more than I'd like to answer in full with a response that the municipalities feel that the lights are worth nothing because they're high-pressure sodium. Nobody puts those kinds of lights in anymore. Nobody uses them. For a number of the municipalities that have been in this argument, they've had those lights up there for 40 years.
So that's just the bulb.
Yes.
Okay, but what about the infrastructure that's attached to the bulb? Would that stay, or would you be replacing that as well?
It would depend on the condition.
Okay, so older infrastructure would need to be replaced.
Eventually, yes.
But some infrastructure would need to be replaced right now.
Not to our knowledge. If it's actually up to code, you would not be required to replace the infrastructure, the mast arm, and all the pieces that go with the Lumiere. The municipalities would want to replace, the bulb, which is not a complicated matter. You switch one bulb out for another. And so,
But you were talking about Chevy Chase earlier,
Mm-hmm.
and said that those lights are so old that so much of that infrastructure would have to be replaced. Is that your understanding?
no.
Okay.
Our understanding is if, as Pepco says, generally, they're up to code, then those fixtures and their housing and how they're attached to the pole would still be able to be used. It's just that we don't know in particular if the ones in a particular town are actually up to code or not, because those kinds of records aren't kept. And you can't ask without incurring a large amount of record review that Pepco wants to be paid for, of taking out paper records, I take it.
Okay, so your understanding now is that the majority of what you would be purchasing is up to code?
It should be. Well,
And that you would just simply be changing out light bulbs?
right. That's what we would expect based on what we've been told, because we don't think that Pepco has got hazardous fixtures out there and streetlights. They're not supposed to. It's supposed to be up to code. And so we would not expect to have to replace a lot of equipment right away, because they should be usable. Otherwise, they're giving us hazardous equipment, which is what we're concerned about,
Okay.
actually.
Okay, and Mr. McKeel, how onerous a task would it be to be able to provide information on what's been fully depreciated versus what infrastructure is new?
That would be a very onerous task. Our asset management system is based on mass plant. So the information goes into the system, like we would have paper, work orders and things like that. That would be inputted into the system, and then those things are put away, sent off, put in boxes, sent off to storage. And, they're just in a box. We'd have to get the box out, retrieve the box from storage, go through the box, and, pull out the work order, tie it to the pole.
Well, the concern I have is, I mean, you're asking the municipalities to pay for something.
Yes?
And what you're charging should that whether something is fully depreciated should be factored in to the calculation of what's being charged. So it doesn't. I guess I'm sort of trying to understand if there's a way to make that calculation. Otherwise, it doesn't seem very fair.
And the way we set depreciation rates is on a group amount. So, the mass plant. So every portion of the mass plant, you're going to be doing winners or losers there. And right now, everybody's paying on a mass plant basis. And we're saying keeping it on a mass plant basis makes it fair for everybody involved. And to get that information, as we say in our initial brief, would be very burdensome, time-consuming, and costly.
Commissioner Barbie.
Thank you. Mr. McKeel, what's the lifespan of a bulb? Is it 30 years? Is it 40 years?
One moment. Lifespan of a bulb is about 6 years, Commissioner.
Okay, what about the housing? I mean, I didn't mean just specifically the bulb, but the whole housing. What would be the lifespan of that?
I don't know the specific depreciation rate for the pole. We have but we have a specific depreciation rate for those attachments that have been approved by this commission. I suspect that depreciation rate in account 373, which Streetlight is, probably around a 30-year mark. But I would have to check to see what our specific depreciation rate is.
Okay, Ms. Ferguson, from listening to you right now, I get the distinct impression that the municipalities are going to inspect these bulbs and inspect these fixtures and will probably very quickly come to a determination of what state that they're in. So in effect, the cost associated with determining the state of the fixture is really being borne by the municipality, isn't it?
Yes and no.
Okay.
It would not be sensible for a municipality to rely on Pepco records so far
Right.
to determine what is actually in the municipality. Our experience is that it's frequently wrong.
Okay.
So there would be a review of whether there's a fixture there and where it is. However, because Pepco doesn't have these detailed records about when something went up there, that's inside a box. You can't see that from the ground. And you can see it from records, but they've said those are too hard to get to. So the only way to be able to determine that would be to open the box, which requires, a lift. And that's that's what they're referring to as the cost of a warranty. They'd have to be able, I think, they'd have to be able to go out there and take a look in the box to see what's there because they don't know otherwise. And so, and also to look at the structure that's holding the light. The municipalities, I don't think the municipalities' review of the lights ahead of time would satisfy Pepco that that's a good enough review for them to say, okay, we agree that what we're handing you is up to code. I don't think they would.
Well, I mean, let me tell you why I'm asking these questions. I would have a big problem with assessing whether a piece of equipment is fully depreciated or not based on a mass calculation, because I have seen some of the street lighting in Gaithersburg and Washington Grove and in Rockville, and I'm not an expert, I admit that, but a lot of those just don't work at all, and I've seen instances where light bulbs have been replaced and they failed shortly thereafter. I've personally gotten the complaints from my former constituents on these things, and so, in an ideal world, the municipalities would have the ability to take a bucket truck up there and look at it and open up the box. They don't have that ability. Only Pepco does. But is there no way for us to have the two of you come to an arrangement where, in the case of lights that are repeatedly failing, which is an experience that I've been made aware of over the course of 32 years, that we can come to a conclusive decision that that device is fully depreciated and therefore the net book value would be zero? Is that utterly impossible for us, for the two of you to be able to do?
Part of that question goes to another issue that we have, which is the valuation of the lights.
Right.
And that's because we agree at this point that it's net book value, but we don't agree how that can be assessed.
Right.
Pepco wants to do it on a mass plant, which
Right.
means that you add in, it's just an average, it's a fiction.
Yeah, no, I get
Okay.
that, because
Right.
I've run accounting systems also, and I have a little bit of sympathy for Pepco in this respect. But regardless of whether mass calculation is the gold standard in Rhode Island, population 1 million, or in Massachusetts, the fact of the matter is we have a lot of defective lights in the little part of the earth that I'm familiar with, and I would hate to assess to those lights a net book value of 50% depreciated when, to a common observer, they're just failing lights, and that for me is a bit of a problem.
And we agree because, and just because it's used to set rates, which it has been forever, I take it, and that inequality is spread out amongst all the rate payers. That's one thing. But what we're talking about now is not a rate case. It is a sale.
Right.
And that isn't spread out over all the rate payers. It's for a particular municipality, which may be very small. And Mr. McKeel has said he hasn't heard me say before that we could put a time limit on the warranty. The municipality's position is that they should be getting streetlights that are up to code. And if they're not, that should be fixed by Pepco. However, but if the commission is not willing to do that, then it's reasonable to set a time period whereby the municipalities would actually, in all probability, be out there for one reason or another and would determine if there was a real big issue. And we're not talking about if just the course of normal wear and tear. Normal wear and tear that happens. At some point, it becomes a hazard and has to be replaced. But if it's not brand new, but is still functional, that's fine. That's up to code. We understand that. And we're not asking to be compensated for that. A lot of these lights have been depreciated down to nothing for a long time.
Yeah.
And that's why they're failing. And the municipalities don't want to take that on, that constant calls for service for things that should have been taken care of under the O&M by Pepco.
Thank you.
Commissioner Richard.
Thank you, Mr. Chairman. Let me start. Obviously, this started as a tariff hearing. We've been doing this for quite a while now, haven't we? We did, move this into hopefully a negotiation, and I am pleased Pepco and municipalities have been able to get as far as they have. But I did hear again today that this is the first time Pepco has heard about the time limit possibility on the warranty. Does that change, since this is news to Pepco, does that change anything as far as the negotiation goes? If there were a time limit, would Pepco be willing to, entertain an agreement of some sort with the municipalities?
Commissioner, that is a new thing that we would certainly consider. I'm not the person that would make that decision, but certainly limiting it to 2 years, as Ms. Ferguson suggested, seems to me to be reasonable. What we don't want is to be on the hook forever and arguing about, was it worn out, was it defective? I understand. I understand the issue in Massachusetts where there was incorrect wiring, right? I'm here to tell you I do not believe that we've incorrectly wired, a city of streetlights.
Yeah.
And
I appreciate it. You don't have to go any further. I just wanted to find out if there was a possibility at this point warranty could be taken off the table. And Ms. Ferguson, do you feel now that Pepco is hearing this for the first time that they're saying that this might be something that could just be worked out today?
I'm recommending that to my clients.
Okay.
I would say that because, and that's based on conversation that I've had with Mr. Woodbury, that generally speaking, once the activities start and the municipalities have to go up there for their own reasons, they're going to see it by and large.
Mm-hmm.
And so the issue will become obvious pretty quickly to them.
Okay.
And may I just respond? If the issue isn't normal wear and tear, like let's say, for example, there's a bolt, and it's rusted or whatever, for whatever reason it's defective, if it's normal wear and tear, that shouldn't be something that Pepco should be on the hook for. Although we're doing maintenance, like I said, we have a 10-year maintenance plan, we do it in grids, we look at it, you don't know. If it is something like we have incorrectly wired the system and it's a hazard, then that would be something I think, and I need to get that for a couple of years we'd be willing to warrant. But there's got to be a clear line there about what that is, so we're not always getting into these squabbles about no, this, that.
Okay, well, I think this is important information then we've heard today, that this is something possibly we can take off the table and it could get worked out. Just to the point that was raised earlier, that a lot of this may have already been paid for. Pepco does have a very, useful, I think, a consumer-friendly outage system, Streetlight outage system. I can go in great detail and see every single one of your lights in your service territory. So it seems at this point, money has already been paid by ratepayers for a system, meant to maintain, and also, is it true you can just go in and click, on a light and say, hey, this one's not working, and it immediately gets put into a queue for repair.
Customers can
So
report
the
for-
operating maintenance budget of the utility already has a pretty robust budget built into it. Is that correct? For O&M.
We do have an O&M budget that is
Right.
recovered in rates, yes.
For all lights, including potentially those lights that would go into a municipal system.
Yes.
Okay.
Right now, because we own all of the vast majority of overhead streetlights, and I want to be clear about the distinction between overhead and underground. We own the vast majority of overhead streetlights.
So
That's
that's
not
baked-
the
that's-
same as underground.
So that's already baked into the cost that all ratepayers are paying for their electricity.
Yes.
Okay. So it is true that it is largely paid for, at least for a discrete period of time.
Yes.
Okay. All right. I think that's, again, would support, hopefully, the Pepco working with the municipalities in a reasonable time period, phasing out or transitioning what should be an operating system, and a system that, in fact, has a warranty of sorts because it's in rates, to a municipality. Is that correct?
Well, yeah. I mean, right now, if a street light goes out, Pepco goes out and fixes that street light. Now the question becomes: we have sold the street lights to Chevy Chase. That street light goes out for whatever reason. The question is that a warranted issue that now Pepco still has to go out and do it, or because the municipality's the owner, they have to take care of
And,
that?
these are details I really don't think we should get into, but I think there's a principle here that it was the expectation of the commission earlier that would get worked out. And it seems like there are if reasonable minds will get together. The municipalities said there's a time limit that they would place on the process. And I think there's an agreement by the company that, yeah, there's already money there to make sure that at least for a reasonable period of time, the system is functioning. The system that has been turned over, been purchased by the municipalities, should function. Is that correct?
Yeah, we are more than willing to talk about the 2-year warranty and what the contours of that are.
Okay, good. And again,
And again, we have
it's just-
we
you've
have
built- you've
resolved.
already built at ratepayer expense this outage management system that identifies by number every single pole and has identified the location of every single existing light. Is that correct?
That is the goal of that
Okay.
system.
So at least the inventory is already started of sorts. And it sounds like it might be, if I'm correct, to the degree to the detail that the municipalities are requesting.
And we are willing to do a basic inventory of
Well, you've already done a basic inventory. It's available to all customers now, isn't it?
right, but just when you're selling something, you want to make sure, I would think.
Okay.
And we're willing to do that to give the utilities the peace of mind. The difference is about whether or not we're going to get the bucket truck out and do like a construction look to see if everything is wired. But the warranty could take care of
In a
that.
sense, we've already paid for that, haven't we? The bucket trucks, the warranty, the O&M is already built into rates now. So again, I'm not here to argue with you. I'm just trying to get a better understanding and hopefully facilitate maybe more effective communications with the municipalities, because it seems like it has not taken place yet. To staff, the driver is a state law. Is that correct?
That is correct.
Okay, so there is a state policy that is promoting the idea that the municipalities should own these systems, and I think we discussed a little bit here, it's for advancing state policies like energy efficiency, electrification. I guess this was already electrified, but for state policy as far as just more efficient lighting systems. So there's a state policy that's driving this.
Yes, Commissioner.
Okay, so there is something for all taxpayers, all ratepayers, in having a state policy, correct, that would promote the more rapid, driving the more rapid, what I'm trying to say, of electric lighting, street lighting.
Yes,
Okay.
Commissioner. No, I see your point.
Yeah.
Yes.
So it's not just necessarily the municipalities that are the cost drivers. You could argue also that this is a state policy and it's for advancing efficiency.
Yes. Yes, I see it from that angle. Yes, Commissioner. Staff's outlook was just on the cost causation aspect of that. But yes, I see your point.
But ultimately, it was the legislature that is the driver. It's a state policy that was the driver of this electrification effort, not electrification, the efficiency effort.
Yes, Commissioner. I think staff's point was just in the context of an individual sale of streetlights. That's where you would have the cost causer in regards to a specific sale. But yes, no, I see your policy argument.
Okay.
If I may, Commissioner, I make that point in footnote 35 on my initial brief.
Okay, I'll go back. Anyway, thank you, Mr. Chairman. No other questions.
Thank you. Mr. McKeel, you had talked earlier that Pepco does a routine inspection, I guess, of all the streetlights. You talked about a certain number, grid, or whatever. Can you give me more detail about that?
We do maintenance as pursuant to our tariff, pursuant to a grid. Globe washing. We look at the streetlights in that area, see if there are any issues, and of course, if there are reported outages to us, either we see them or they're reported via our outage map. We endeavor to do those repairs also.
So, but I guess I'm trying to get a sense of how big a chunk of the streetlights do you do when you do these inspections?
It depends on how many streetlights are in the grid that we're doing. So it'll depend on the population centers that we're doing, whether or not there are a lot of streetlights in that grid that we own, or if the streetlights are a large number of underground streetlights or streetlights owned by MDOT. So I can't. What I'm telling you is, you look on the grid and there are a certain amount of streetlights that we own, certain amount. So certain grids are going to have more streetlights. Certain grids are going to have fewer Pepco-owned streetlights.
So, but I would think that there'd be more recent, more contemporary records of the status of the streetlights based on this inspection that you do?
When you say contemporary records, I mean, we know that our contractor has gone out and, washed the streetlight globe. If there is a streetlight bulb out, we would know that. We would have that record. We would keep it for a little while and then we would store it. But we don't have records back. Readily available records back. But yes, I think we have records, and let me check. We would have records, like how many repairs we did this month.
Okay.
Is that right? We would.
Okay. So I know streetlights have been a topic of discussion amongst energy folks for a couple of decades now, about trying, because they're viewed as one of the things that could be changed either for safety purposes or environmental purposes, things like that. Are there any plans that you're aware of on the part of Pepco to do any significant change, upgrade to the streetlights?
Yes, we have a plan. We've just set up an outdoor street lighting department, which is something that we haven't had. And obviously, as part of this, we're here today about the model street light agreement and the model purchase agreement. But there were also, as Commissioner Richard noted, this started as a tariff filing. And we are also working on getting LED tariffs and working on getting in place a plan to convert our high-pressure sodium streetlights that are company-owned to LEDs. And we had put forth a plan in our MYP, our first MYP, and that was rejected by the commission. And so we continue to talk with the municipalities on the tariffs, both for the purchase of and the Pepco conversion. And so we're also working on that track with them, getting their feedback, as Ms. Ferguson said, about a dimming schedules and things like that. So yes, that is underway, but we're not ready to put that proposal forward yet, but that's something we have been working on. So again, we're just trying to go, so because there's a lot to go on with streetlights, there are two paths, right? What are we going to do to comply with the Local Government Act 1309 that requires us to sell streetlights if the municipalities want to do that? One of the things we heard is we need attachment agreement, purchase agreement. We agree with that. And we need tariffs that deal with that. We agree with that. We're working on all of that. The second path is Pepco converting its company-owned high-pressure sodium streetlights to LED. And we're also working on that track. But they're separate tracks right now. And they should be because they're separate issues. Related to streetlights, but separate street lighting issues. So yes, that is underway.
Okay. Any other? Okay, so I guess we can move on to.
So I still would like to focus on the cost, the actual cost. You know, you're selling plant somewhere in your system, and you'll know what's been depreciated. You'll know the value. There will be a valuation. It just seems to me that the valuation is not really tied to the actual value of the infrastructure that's in place on the one hand, and then you're also shifting a lot of the responsibility to the municipalities because they are going to have to maintain it, and then there is a maintenance cost that Pepco will no longer have to bear. So there is sort of value to you as well that I haven't seen reflected in any of the documents that I've seen. So if the municipalities are willing to limit the warranty to a 2-year term, I just wonder if there's a way to make a determination. It doesn't have to be, individual by individual light fixture, particularly because of the warranty issue, so that you are sort of recognizing that there may be problems with particular lighting fixtures, and you don't have to send the bucket trucks up to each one of them. So if you're able to do warranty that reflects the fact that you won't know precisely which systems will present problems in a year or two, maybe there's a more streamlined way of making a determination about what parts of the system have been fully depreciated and paid for, and then the stuff that's kind of newer. And sort of following Commissioner Richards' suggestion that there are ways of compromising, where you get a little something, municipalities get a little something, but also that reflects the both the value of systems, but also the risks that you're going to be taking now and into the future, because the municipal systems are taking on a risk. And after that warranty period, the risk is all being the burden of the risk is on the municipal systems completely and completely off of Pepco. So there's some value in that as well. So I'm just sort of asking if you can think a little bit more about a way to present value that that is not, sort of this say, sort of amorphous average, sort of really based on not the system as it currently exists.
Okay, actually, before you get started, Ms. Ferguson, looking at the clock, apparently it's 5:12, so this is probably a good time to take a lunch break. So we'll come back at 1 o'clock. We're adjourned. Back on the record. One quick thing. Commissioner Richard has a conflict at 4:25, so we're going to keep going, but I would like him to be here for as much of this as possible. So if we could kind of maybe pick up the pace a little bit as we're going through the afternoon. And so with that, Ms. Ferguson.
Thank you. So the second question is, and we've gone over this some, and the basics for the issue here we've already talked about, so this should move this along a little faster, as to what the calculation for the purchase price of the streetlights is. Pepco has proposed that we've agreed that it's the net book value, but how we get to net book value is where the disagreement is. Municipality's position is, as MEA talked about, it's the cost minus the depreciation. The Pepco has indicated that they are not able to designate the cost of a particular piece of equipment for the reasons we talked about before, because of the record keeping. And so they want to rely on the mass plant like they do for rate setting. And as I said earlier today, it's a fictional way of looking at things. Doesn't actually apply to the piece of equipment that you're buying. And while it's been the habit and the procedure that's been followed for years just as a way to set rates, now we're talking about pieces of equipment that are particularly identified in a municipality that they want to buy. And the municipality's position is that they should be able to know what net book value is for that, instead of accepting the mass plant. And Pepco's position is that if in fact the municipalities want to have that specific a piece of information, then they will have to pay for it. It's that same, you're causing this problem, so you're causing this thing to happen, so you have to pay for it. Municipality's position is there should be records there so that you can tell us what we're actually buying, what things we're buying, and the municipality shouldn't have to pay for that. And again, there's the response that this will put a cost on the ratepayers, and our response again is that's a much broader class of folks than for one small municipality that is paying for something maybe that isn't the case, such as Section 3, whose lights are very old and not useful to them, and have been depreciated clearly down to nothing. But they're not able to get that valuation because it's being based on mass plant and not what's actually there. One of the things that also occurs is that the state has already said, municipalities, we want you to buy lights. And we see this as another one of these barriers that gets put up, money barriers. It's going to cost you for this, and it's going to cost you for that. And right now, I had an update on the cost from Mr. McKeel within the last couple of days as to what an individual fixture would cost, the streetlight would cost. And it was in the high 100s last year. Right now, for a 6-month period, I think it's 207 and some change. And as Pepco follows its program through and starts, as they've indicated, replacing LED lights for the old lights, values are going to start going up then across the mass plant, but not necessarily in a municipality. So that someone's with lights that are very old, but Pepco hasn't come through there and hasn't changed them, would still be paying a price that's based on the rest of the plant that doesn't really have anything to do with them. And I believe that one of the jurisdictions that we had looked at about this was the District of Columbia, which has bought its Pepco lights, and were able to buy it on the basis of what the specific lights were, what they actually were, and what they were paying for. So it's the same issue spread across not only do you know what's there and what the condition of it is, but also over to do you know what's there in terms of determining the value? And Pepco does not without the same laborious review in their boxes that they've discussed. And if the municipality wants that done, they have said that you're required to pay for the truck coming out and opening the box, which is another barrier to entry here. So just to get an accurate price. So that's this second issue. It's related a good deal to the first.
Mr. Markeel.
Sure. I think Ms. Ferguson incorrectly stated what happened in the District of Columbia, and those lights were sold as a rate case settlement in 1984. And so we never talked about that in any of the meetings, but that's just not a correct explanation of what occurred in the District of Columbia. I think we have talked about this, and, you know, in keeping with the time issues, I will be brief. We think it's appropriate to use mass plant. I think if we don't use mass plant, we're going to be creating winners and losers. Again, moving costs from the people that remain, from the customers that leave to the customers that remain. I don't think that that's an appropriate way to do it. It's not about whether or not we go out and have to look at the boxes or whatever, like Ms. Ferguson said. The issue is we would have to retrieve all of the paper information because, as I noted in the initial brief, because we use mass plant for basis of setting rates and depreciation, our systems weren't designed to do it on an individual light basis, which is consistent with the vast majority of utilities in the United States, despite what Mr. Woodbury may or may not say. And there's going to be a cost to that. And again, I think we've had a solid regulatory principle in Maryland that the cost causer pays, and the cost causer here, but for this requirement, is the municipalities. They should pay it. It should not be the ratepayer that pay those costs. But that's a determination that this commission has to make. I would also point out that contrary to what the municipalities say, there's no requirement at FERC, at this commission, that I'm aware of, or that the municipalities has pointed out, that require the tracking of streetlight equipment on an individual unit basis. There's no such authority. It's not required. And I think everyone agrees here that our rates and our depreciation are done on a mass plant basis. And I explained that in the brief. So this whole idea that the records aren't available, this is a relatively new statute. We didn't have it before, so there was no reason to develop our systems like that. And so we think it's appropriate to use mass plant, consistent with good regulatory practice.
Mr. Greger.
Thank you, Your Honor. So staff is sympathetic to the municipality's position on this matter, but the fact is that the records are either too difficult to get for the company or don't exist to get those granular characteristics of individual streetlight units. So there's going to be some incremental cost associated with finding those characteristics or capturing them during the course of a pre-sale inventory or survey. So those costs have to be allocated somewhere, and then staff would just like to reiterate our initial point that if the company bears the costs associated with those incremental costs, ultimately it will be the ratepayers that pick up the tab on that. So yeah, basically that's staff's position on that, Your Honor.
Ms. Ferguson.
The municipalities and local governments are willing to live with reality. And reality is that it's possible that the equipment is worth less in one jurisdiction and more in another. And that is, in fact, what you're buying, whatever is up there. And so to say it's not fair to certain jurisdictions, actually, the system that's being used right now is not, quote, fair, because it assumes just a certain value across the board, even though that's not the case. And it is recognized in the industry for rate setting. And there's a reason for that. The reason is that it would be too difficult to set rates in the periodic way that they have to be set on a constant basis. To be able to do that, it would be prohibitive. And so the municipalities are not arguing that using mass plant for rate setting is accepted and fine. It is accepted, it is fine. This commission has recognized it. That's fine. What this commission hasn't recognized is using mass plant for evaluating the sale of particular pieces of equipment to the municipalities. That's a different thing, and it can be determined. I mean, if what Pepco is saying is that no matter what, they can't tell what it's worth, that's something else. But if there's a way that they can look at it or look at their records and tell you how long it's been there and what it is, which is not a real in-depth type of arrangement and could be maybe even bolstered by the maintenance reviews that Pepco does every 10 years, but we don't know what kind of records they keep of that either. So they chose some time ago, and of course this law was adopted in 2007, I believe, so it's been quite a while. And to be able to keep the records to determine what something is worth could have started then, but didn't. And this is the first time we've all dealt with this in depth and really came down to these questions. So again, the municipalities aren't causing this. This was a choice that was made to apply to another situation altogether for very good reasons. But those reasons don't apply here because we're not talking about setting rates which have to change over time on a repeated basis. We're talking about a one-time valuation of a piece of equipment. And so we find this quite different, and all the authorities that have been referred to as various states having accepted that as the way of evaluating what these pieces of equipment are worth is really only applying to rates, not to the equipment itself.
May I respond?
Sure.
I would just say that, but for the request being made by the municipalities pursuant to Local Government Section 1-1309, Pepco would not be required to determine the locational net book value of street lighting equipment. And it is that request that is causing these costs to be incurred.
And if I may respond, if Mr. McKeel is finished.
I am.
Oh, thank you. The state decided that. The state decided this is the way to get LED lights to be put in a place, and we can see it's been quite a long time and they're not here. So it wasn't the local governments that, it's not a but for the local governments. We're following authority given by the state. Thank you.
And I'm okay with that. And again, I would point to footnote 35. Expenses to comply with the mandate of federal or state law have historically been recoverable from ratepayers. And so this commission has a question, are those costs going to be recovered from customers? Or are they going to be recovered from municipalities?
Okay. Any questions from
Yes.
Commissioner, Commissioner Sussman? Start with him.
So I'm hearing that there is there's going to be costs associated with trying to make determinations of value for a new piece of legislation, and nobody can ever predict what new requirements are going to be imposed on any entity, and oftentimes, you know, the reliability legislation was passed, and those were enormously onerous costs on a utility that they had never anticipated, but they had to respond. And so you've got you've got Maryland sort of stepping up and saying, the legislature saying this is an important thing and we want this to happen. The fact that you don't have in place, you don't easily have in place methods to make determinations of fair market value doesn't mean that you shouldn't be required to do that, because you're faced with a piece of legislation that the legislature passed. You do mass plant for rate-making purposes. That's what you have in place, but it doesn't necessarily mean that that's what you should be doing in this instance. And it's not to say that you should go back and look at your contracts or try to reinvent if you don't have them. For each lighting fixture that's in place right now, it's just hard for me to imagine. Utilities are very good at sort of figuring out how to move forward with new obligations, that there can't be a way in which you can calculate fair market value that better reflects what the fair market value actually is. Is there a way that can be done in a way that's not, and I don't know what the costs would be to actually do what the municipalities are asking you to do anyway, but assuming that they are onerous, and I don't see the numbers to back that up, but is there another way that this can be approached that better approximates what the actual market value of these lighting fixtures are?
So if I can take
Please.
it first, we had work groups at the direction of the commission on various topics, and as you correctly point out, the statute 11309 says that we're required to sell our streetlights at fair market value. The legislature did not provide any definition of what fair market value is. We provided to the municipalities 4 separate calculations of how we thought how fair market value could be determined. We looked at other states and agreed with what the municipalities said, that for this purpose we would use net book value. And again, it's in my, let me just find where it is in my,
But they didn't ask you to then use mass plant to determine net book value.
No, and that's why we're here. There's a disagreement between how you determine net book value. But I heard your question as, are there other ways to determine fair market value?
That are more consistent with the concerns that the municipalities have expressed. So there are lots of different ways of calculating, but given that they have particular concerns about the actual value of this infrastructure,
Right.
is there in place a way in which these can be calculated so that it better approximates what the actual value of those facilities are?
All I can say about that is during the negotiations, the municipalities, and Sue Ellen will correct me if I'm wrong, or Ms. Ferguson, were pretty adamant about the use of net book value.
No, but I'm asking you.
Okay.
So let's just take off the table the conversations that
All right.
you've had with Ms. Ferguson. From what you know about your system, is there some other way in which these assets can be valued that more accurately reflect, and you're not sending people up buckets, but more accurately reflect what the actual value of those assets are?
So I am not qualified to answer that question, but I can tell you that I could ask, our accounting folks, if they're, our accounting folks that handle this, if there's a different way to do that valuation, that would be reasonable.
Okay, because if I can tell you right now, I'm not convinced that mass plant makes any sense And this is not, you know, this is not for rate making purposes. You're selling, you know, you go and you want to sell a car, you know, they're going to want to look at the car. They can't just sort of, you know, you can't do it based on, you know, if I was Carfax, you know, average of all the cars on my lot. So, you know, I don't know where the other commissioners and the chair are on this, but if I'm having a heartburn with the use of this for purposes of determining fair market value, maybe there's another way that we can get to the calculation that gets closer to where the municipal parties are and also better reflects what the actual value of these assets are.
We're open to trying to do that.
Okay.
And I would just point out, I want to make sure that there are some new commissioners here. This isn't about any sort of profit that Pepco is going to get for the sale. Any amount that we get from selling the streetlights is returned to the customers. And so we are concerned with making sure that we get the appropriate value for these assets that the customers have paid for so we can return that to them. There's nothing in it for us. So we're trying to be customer focused
Sure.
in this.
Understood. Commissioner Barve.
Thank you, Mr. Chairman. Ms. Ferguson, let me try to get to Commissioner Suchman's attempt from a different angle. And let us say that the commission agreed with mass plant as a calculation, and let us say the commission agreed with a 2-year warranty. Washington Grove buys all its lights. Let's say they pay $100,000 for them. And on the first day after the purchase, they go up, inspect it, and just say, you know what, this is just junk. It's scrap value. It's not really $100,000. It's not $50,000. It's scrap value. That's all we're going to get for this. So what then would happen in the interchange between Washington Grove and Pepco when Washington Grove, at their expense, goes up and discovers that particular pole is worthless, that particular device is worthless? What under a warranty mechanism would occur at that point?
That is, in part, subject to fine-tuning, but what we're concerned about with the warranty is the safety aspect of it. The municipalities do not want to inherit a system where there's some basic big problem that they will then have to fix, or it's hazardous or dangerous or doesn't comply with applicable statutes and rules. And therefore, Pepco could turn right around at that point and say, bring it up to code or you're off the pole. So that's an extreme, but that's the concern about the warranty. I know that Mr. McKeel was worried about a bolt. I think bolts are kind of like wear and tear. If what we've got up there is something that is so rusted that it's hanging on by you know, a little piece, that's one thing. If what we're talking about is, you know, not a not new mechanism or equipment, but understandably that's what it looks like at this stage. You know, that's not a warranty type of issue. We're more worried about those wiring issues, the big ticket issues. The municipalities will have gone out and taken a look on their own before they offer to buy, just for a cursory. So they're going to have some idea, and that's part of the issue. They're going to know, I mean, the folks that know how to do this can look at those lights and say, you know, that's 30 years old. That arm and everything, that's 30 years old up there. That's really worth nothing. That should have been depreciated down years ago, and was probably depreciated years ago. So that's the concern here. We're not trying to put Pepco in a bind whereby they are guaranteeing the municipalities a new system. That's not it. It's that they pay for what they get. That's the gist of it. Not more, not less. They just pay for what they get. And then if there's something in what they get that is a hazard because it's been done wrong by Pepco as opposed to the fact that it's 20 years old or whatever, then that is something that they would use the warranty for. As I see it, I mean, it's theoretical, but that's how I see it.
I mean, one concern I have is that I think it's safe to assume that the municipalities that will want to buy the lights will be the ones that have the worst lights because they want them to function properly, and so almost by definition, those devices are going to be worth less than the average throughout the whole system. I mean, is that a fair assumption to make?
I think there are going to be a number of municipalities. In fact, I know there are at least a couple that feel that way right now and would like to just get this taken care of. But, you know, there are a lot of communities now also who they have adopted sustainability priorities in their strategic plans. They want to go to the LEDs and have been waiting a long time and don't want to see any more barriers thrown up to that than there already are, because they're going to have to pay for this with taxpayer money. So I think, yes, the ones who have the really old lights are going to want to get rid of them if they can, if they think they can afford it. But others will too, just from the perspective of trying to be more green and save money. You save a lot of money not using those bulbs.
Yeah.
So.
I mean, just for myself, I'll say that mass averaging is a great way to do rate setting. It's a terrible way to actually determine what the value of something, one particular something is. And in this case, it's especially bad because the municipalities that will want most to buy the lights will be the ones with the crummiest lights. Thank you, Mr. Chairman.
Commissioner Richard.
Thank you, Mr. Chairman, and I guess a lot of the questions have been well covered and answered, and I guess asked and answered. But just to kind of really dig a little more into this evaluation question. So this, would you agree, the 2007 is about the right time frame that this law passed, Mr. McKeel?
I'll accept that.
Okay.
I don't know.
And during this period of time, it's an act of the legislature
Yes,
to
sir.
mandate that this should be an option. In that period of time, it sounds like you would have had the company opportunity to, through its maintenance procedures, have looked at the entire system, your entire system. Did you do anything in response to that law? Did you take that law into consideration when you were doing your inspections, reviews? A lot of light may have been replaced and damaged.
No,
So
I don't
did
think
the
we
company do
did.
anything?
No, I don't think we did, and the law doesn't have any specificity in it that would require us to do that, and the law just says that we should sell it at fair market value.
Okay,
So it didn't say it should be net book value at the specific level. And as I said, we had different views about what the fair market value should be, and we set those out. But in order to try to get an agreement, we moved to the net book value calculation.
Okay. I mean, as you can hear, there's, I think some skepticism about whether we should be using mass
Understand.
inventory. And I'm in that camp too, so
Understand.
you've already see three of us that have that problem. So I guess first I'm just trying to get at, did the company take any initiative whatsoever? And I'm hearing there was no. The law was passed. You knew that you would come to potentially a point in time where you were going to transfer or sell these assets. So the company didn't do anything in response to that law
to say we
that was
didn't,
passed in 2007.
I want to be careful about what you mean by we didn't do anything. Did we specifically say, okay, we're going to be selling these at net book value based on the individual cost of the light, and therefore we have to reconfigure our asset management system and our computer system to capture that information? No, we didn't do that.
Okay, so you didn't even think, because in this period of time, we're talking almost 15 years, you went out and you inspected. Is that true? Did I understand correctly?
Well, we have a maintenance program, and
You
I
had
would
your-
assume that we've looked at every light in the maintenance program.
Okay, and in that period of time, you created the outage online system, which is, I think, to citizens and to your customers is very helpful.
We
The fact
did
that
create
every
an
single
outage.
one of Pepco's light and light poles is on the internet, and I can simply click it and report a problem. So
We did
so
create
you
an outage
created
map.
that in the last 10 years as well.
Yes.
Okay. All right. I'm just trying to understand what the
And-
company's
and
done to this law.
I
for this
want to
law.
I want to be clear that it's my understanding that no investor-owned utility in the great state of Maryland has sold their company-owned lights pursuant to this law.
Okay, well, but again, the question is, did you take any action? And it sounds like not really.
Because the law
you-
didn't require us to take
because
any
it didn't require-
action.
So no initiative was taken. Okay, and it sounds like you've already been asked about alternative methodologies to provide some value. The law doesn't require the sale of, every single light. It requires just in a jurisdiction. Those particular lights need to be valued. So, clearly there are a few of us here who would like to have some alternatives. Let me, maybe if you, a bench request or some other kind of action, the company might consider providing that information so that those of us who might want to consider something other than mass value might have something in the record to look at. And
So-
I'd ask staff. I'm sorry. Did you have it wasn't
I
really
just
an
wanted to-
question, but go ahead.
I just wanted to say that that information was provided in the first go-round that we had, where we reported back to you, where we had the meeting on the determination of fair market value, and we set out various ways to determine fair market value. And the second way we set out, and you can see it, it's attachment I to the initial brief, was the concept of net book value with mass plant. So you have that information.
Okay.
And we also had it in response to, I believe, and Mr. Greger will keep me honest here, it was in the buck sheet for the initial tariff, and I believe it was our response to staff data request 220, and I believe I mentioned that.
I think
If
you
you'll
mentioned-
just bear with
I
me.
will, so I'll put it
Page
on,
11 page
I'll put it
11
on
of our
myself to
lit
go back to some of the very first filings that we looked at since the numerous status conferences. But
Right, and it's set out in the initial brief,
Okay.
the 6 items that we said we would look at page 11, Your Honor.
very good. I will make that my responsibility to go back and look up those first filings. Mr. Greger, does staff have anything, any methodologies, if we didn't want to go with the mass valuation, that we might consider? Could we do perhaps a sampling or something that might be less costly than going to every single, fixture, but something that we might provide something maybe more as Ms. Ferguson said, real, as far as the assets they would be purchasing.
Nothing specific, Commissioner, but as Mr. Mike Hill indicated, the company did present several methods to staff during the inception of this street lighting matter. And some of them did take into account characteristics of specific lights or groupings of lights at a more granular level than the mass accounting, such as age-weighted.
Age-weighted, okay. So there could be a sampling and other methodologies. I would just also request, maybe for the record, that if staff have some options for us to consider if we were, to want to have alternatives to looking at these en masse. Ms. Ferguson, do you have anything for the record that we could look at?
I do, and there was a very heavy discussion about this over time, and as far as I recall, all of them were based in part on averages, not on specific costs. And on top of that, this seemed the least lopsided to us. Frankly, that's why we've always been at net book value minus depreciation is the fairest way to do it. These others had to deal with lost revenue streams, an estimate of aging condition, a third-party survey paid for by the customer. This is all on page 11. That got us all into the places where we didn't want to be and sounded expensive and actually didn't get us to a better place. And so that's why we started with and stuck with where we are.
Net book value, okay. All right, maybe would something along the lines of net book value, maybe a sampling. So again, we could kind of manage the cost, but also try to at least have a path forward in meeting this legislative requirement. Mr. Gregory, do you have any?
No, that is something staff can take another look at.
Okay,
And,
great.
and just to follow up on what Commissioner Richard was
Thank you, Mr.
suggesting, can you do the sampling that is municipal specific? So if there is a municipal system that has very old lighting, you shouldn't be comparing that in terms of cost with another system that is relatively new. So can that be done? So you have, a representative sample of Washington Grove to make the determination of what the fair market value is for Washington Grove, and then a representative sample for Chevy Chase, and that would go to the valuation of Chevy Chase. Does that get more to what you would think is a fair?
I think
representation?
statistically, that would be a very difficult stratified random sample to compose. You wouldn't probably have just going back to junior year statistics, you wouldn't have a big enough population to do that kind of a random sample, I don't think.
I had thought that possibly you were talking about just using a random sample of one or two lights in a community and then using that as a general reference guide.
But I don't know that it could go outside the community based
No,
on what.
I mean in the municipality.
Right, because what Commissioner Barvey mentioned earlier was that we're probably seeing the municipal systems that have the most compromised lighting systems. So you don't want to use those to compare with other systems that have more. So if you could find a way to maybe be very community specific in how you do the calculations, maybe that can get closer to what your concerns are.
And just a clarification, that's what I intended. It would be a sampling of, I guess, the municipality, those specific lights. So yes.
Could I have one last bite at the apple here? Here's what I would love to know from the accounting department from Pepco. And I'm thinking about the depreciation schedule on the companies I've run in the past. Even if I couldn't tell you exactly what each item was, I had a very good understanding on a year-by-year basis of how much was invested and how much depreciation occurred in that year. Now, the reason I mention this is that might be a quick and dirty way to figure out what the average life of these devices system-wide are. We may discuss, I think that would be a way to, in a backdoor fashion, figure out that the average light pole is 25.2 years old, or 17 years old, or 35 years old, and indicating that a big chunk of the system is depreciated down to zero. Ask your accounting department if they have the ability to pull numbers like that, because I think that might be a neat trick to figure this out.
I just want to make sure that I got it
Sure.
written down right, sir.
Yeah.
How much investment was made in streetlights, and how much depreciation was incurred in streetlights for a year?
For like the last 15 years since the law was passed.
Okay. Thank you. I
Thank
just want
you.
to make sure I'm getting you what you need, sir.
Yep, thank you.
I will ask.
So, Mr. McKeel, in reading your initial brief and this discussion about this issue, at the risk of entering into jargon, I mean, the process that you've used for allocating these streetlights and the FERC account that's referenced and the process that you use for the determination, these are all the things you do as part of your depreciation study, correct?
Yeah, and you can see that process in attachment I, which is a sample fair market value calculation using that.
Okay, So my one question is, when's the last time you did a full depreciation study for a rate case?
I believe we had a full depreciation study in our last MYP case, and my recollection is that we have a depreciation study in our pending MYP case.
I see. Okay. Okay, thanks. Any other questions?
Let me just, if I could just follow up. Ms. Ferguson, you said something earlier about how you have your sort of contractors, people that would work for you on this, that can sort of eyeball a lighting fixture and know if it's a problem or not without necessarily going up. Is that what you were saying, or?
No, I think that the folks who do this, there are some companies, and Mr. Woodbury's has been part of one,
Okay.
that operate the systems for municipalities. And someone like him or people he employs can look at a fixture from the ground and look at and see generally what the condition is. But to have the kind of information that would satisfy Pepco in lieu of the way they set their values, which is their mass plant, you would have to go up. That's what they've told us anyway.
Okay.
They would have to go up and look in the box and be able to get the age of the equipment and other records or other information about it. So
Mr.
that's
McKeel,
fine.
is that right, that you'd actually
No,
have to
you
go up?
wouldn't have to go up and look in the box. What we'd have to do is get the records back and look
Okay.
at the records that, on this day in 1985, we put on this information, this bracket, this light bulb on this pole.
Okay, so when you sell a facility, you do due diligence. There's an enormous amount of work, and you bring lots and lots of people into the process. I'm still trying to get my hands around why it's such an onerous task to calculate the value. I mean, are we talking about? We're not talking about millions of dollars that would be involved. I mean, is it? If it's two people, I mean, you've got how many light posts or light poles are we talking about?
66,000.
We have about 66,000 company-owned streetlights as set out.
No, that are part of this where the municipal systems are trying to take ownership of. 66,000.
Well, they could purchase all 66,000 if they so chose.
Okay, Ms. Ferguson, how many are we talking about?
I don't know the number of the municipalities. It wouldn't be the six. You're saying municipal 66,000 is all the street lights,
All the overhead company-owned streetlights.
right? So that's in unincorporated areas and incorporated areas. So each municipality has its own set of lights, and Pepco does have records now that show how many are in each municipality. Mr. Woodbury who's been quoted by everybody here, and I quoted this in the brief, about the value of the streetlights here as compared to all the assets that Pepco has is tiny. It's tiny, and you're talking about something that doesn't even move a decibel.
Well, it
decimal
could be
point.
tiny, but the challenge is even a tiny asset can involve manpower to
Yes.
make determinations of value. I'm just trying to. So you're talking about 66,000 lights that we're talking about that your clients would take ownership of.
No,
Okay.
they're not going to take ownership of lights that are not within their jurisdiction, because then you run into the county.
Okay. So how many are we talking about?
Do you know that answer?
So it would depend on jurisdiction. What I'm trying to tell you is we have 66,000 streetlights. Some of them are in Prince George's County who could buy them. Some of them are in Montgomery.
Okay. We're just very focused on just your clients. I'd actually like to have a number. I mean, if we're talking about like 500, that doesn't seem onerous. I know that there's going to be more than 500.
I'm
but-
sorry,
but
I misunderstood your question. You're wanting to know
How
for
many-
7 clients, how many streetlights they have.
no. How many streetlights do they want to buy?
Oh, okay, I can't say that. I could tell you how many are in each jurisdiction.
Yeah, because, I mean, sometimes we get so focused in on sort of bigger picture issues and we don't sort of distill it down to, so if I can have a sort of a sense of how many we're talking about, that can also, sort of play into how onerous would, if we're talking about, hundreds of thousands of streetlights, it would be really, really hard to go from light to light to make a determination of what the value is. But if the universe of lights we're talking about is much, much smaller, then the obligation of what to do to make a fair market determination changes.
I'm getting some input from those that are attending from municipalities. Am I hearing 5,000 to 6,000?
In total,
Yeah.
for all of your 7 clients, so 5,000 to 6,000.
Oh, that's more than them, I think.
5,000 to 6,000 lights.
The people who know the answer to that best is Pepco. I can ask the municipalities.
Yeah. So let's see
for-
if we can get a number
So,
on that.
so why don't we make that a bench request, that between the two of you, you get us an answer as to what the universe is of this,
The universe of
Just
her
for
clients.
her clients. her
Okay,
clients,
thank
yes.
you.
Mhm.
And I'm sorry I didn't
No,
understand.
no,
No,
that's
no,
fine.
no,
I mean,
yeah.
and it's actually really important that
We're just-
that we end up on the same page.
If I may,
Free
if I
zone.
may, this effort is not intended just to be about my clients that are here. There are any number of municipalities that don't have the wherewithal to be here. This is an expensive proposition for all the time that's been spent. Everyone is interested in this and have allowed this group to kind of take the lead and bring up the issues, but they're all interested in the answers to these questions and want to be able to use the template agreements that come out of this that removes another barrier so that there doesn't have these negotiations all the time. So what would be a useful, I can get the ones for the municipalities that I'm here on behalf of today, but I think it might be helpful to know how many there are in toto
That would be
in
fine.
the municipalities.
That would be fine too.
Sure. Okay.
That's the 66,000 then, if it's in total, because those are the municipalities and the county.
You probably have this in your database by zip code, the location of your lights, don't you?
I don't know if it's in our database by zip code, Commissioner.
Okay.
I just don't know sitting here.
Okay, no, I'm because I was thinking about Garrett Park, Maryland, and they were only one zip code. And if you had it by zip code, you'd be able to figure out what Garrett Park's number was.
Sure.
My understanding is that, I think Mr. Lipari has said that each of the municipalities, they have the information for and can provide it if asked for. So I
And-
assume that number's there somewhere.
And I believe some of your clients have asked us that question, and we've
Right.
provided that information.
Right, so that's why I was assuming that Pepco has the information.
Now, according to the list of issues I have, the next topic has to do with the participation of Verizon in this process. And I guess from our standpoint, our view is that Verizon needs to be involved in this process. I guess what I would like to hear from the parties is if there's any reason why they shouldn't be, and then the next step would be, how do we go about involving them?
We certainly think, and this is more of our issue. Verizon has told, Pepco has told us that they do have attachment agreements or various types of agreements. Some of them are very old. We've not seen any of them, but there are agreements with Verizon to place Pepco property on Verizon poles. We had asked in our original proposal to change edits to the agreement, had asked that Pepco agree to assign those rights to the municipalities that buy so that they get the right to be on the pole in the same place, et cetera. And Pepco has said that they cannot do that for whatever reason. I think we have a disagreement now as to why, but I don't think that position has changed. They say they can't do it or they won't do it or whatever. So even if we have these template agreements that we reach, the next step then is to talk to Verizon, and we'd be getting into it all over again with them. Mr. Woodbury reports on an operational level that trying to get in touch with another utility, Verizon in particular, but others, even though the Maryland law says that they're presumed to allow you to proceed, you can't get them to answer. They just don't respond. And so you have work that you need to do, but nobody who's responding to you and no understanding that you have consent or even about any particular situations on that pole. And so we wanted, and being informed by that, we wanted in this agreement some type of reassurance that if there's another utility involved as a joint user, that the municipality has a right to assume that that agreement is going to be applicable to Verizon or whomever, not private parties, but public utility parties.
So just so I'm straight, though, the municipalities have not had any contact with Verizon, correct?
No, my understanding was that actually staff was going to get in touch with them.
We did reach out to Verizon and request a point of contact for their street lighting, or not their street lighting, but their poles. We're waiting to hear back.
I see. Okay. So, Mr. Mike Heel.
So we have no objection to having Verizon come here, but the agreement should be between Verizon and the municipalities. We pointed out that we have joint use agreements between Verizon and Pepco because we each own poles, and that those agreements do not have assignment provisions. So the contracts don't have assignment provisions, so we can't assign those contracts. We also pointed out that the joint use agreement between pole owners is for the use of poles, each other's poles. Since the municipalities don't own poles, that assignment, if we could assign it, but we can't, would be of no impact to them, right? Because municipalities don't own poles. So we are sympathetic, and we provided our contacts to Verizon, to the municipalities, and we're happy to have them involved. We're not trying to do anything, but we cannot contractually bind Verizon to do something. We don't have that authority.
Okay. And you have not had any discussions with Verizon about this subject?
No reason to.
No, I understand. I'm not saying that you should. I just want to make sure that, so at this point, aside from staff trying to get a hold of Verizon, no one has talked to them.
That's my understanding.
Okay, all right.
Just for staff, I just want to make sure I understand your testimony or what your filing. If I'm reading this correctly, staff says that local government article would require Verizon to honor any rights and obligations under the pre-existing agreement it had with Pepco regarding the attachment with the municipality. Is that the position of staff and staff council?
Yes, that subsection F would require Verizon to honor any pre-existing contract they had with Pepco, apply that to the municipality that would purchase Pepco street lighting for that Verizon-owned pole.
So just so I understand, that's in conflict with what Pepco is saying?
We have a joint use agreement with them. We don't, which gives us the right to put items on our pole. And I'm going to talk to Mr. McGee. Am I getting that correct?
It's a joint use agreement.
Okay.
Yeah, for the joint use of each other's poles.
Okay, maybe at some point we can get a clarification on, from staff and probably your counsel on, it sounds like staff is telling us that there is a requirement that those agreements
Yes, that's how we
the
read
agreements be passed
11309
along.
now.
Okay, so we have potentially a conflict of information here.
So,
Well,
but-
and it may not involve Pepco at all. I mean, the joint use agreements, I think I agree with you on that. There's nothing to assign because they don't have poles. But it may be that Verizon, it's not that they are required to honor your contract, because the contract is a joint use contract. It's that they just are required to allow the lights to stay on that pole. So it may just be that we need to get Verizon in so that Verizon understands what their obligations are.
Could we ask, Mr. Chairman, could we hear from Mr. Dane, your staff counsel, just maybe we can get a clarification on what, I guess, what the authority of assigning these rights?
Well, we're pointing out that the local government article, section 11309F, specifically states that any person who controls the right to use space on any pole, lamppost, or other mounting service previously used in the county or municipality by the electric company for street lighting equipment shall allow a county or municipality that has purchased the street lighting equipment to assume the rights and obligations of the electric company with respect to the space for the unexpired term of any lease or other agreement under which the electric company used that space.
Okay, so do we still have a problem, I guess I'm asking?
Well, I guess my concern is, until we actually hear from Verizon that they say, we agree, I'm not going to assume that that they're going to just go along with this. So I think we need to have some contact with them and have them either show up here and argue a different view of this, or for them to say, yes, we agree, in which case we can move on. But at this point, I don't want to speculate as to what Verizon's opinion is. So.
Thank you. That is our concern too. And I don't know when the contact was made, but I think the direction was given at latest sometime in May this year. And if it's been that long and Verizon hasn't gotten back, I think that Mr. Woodbury's experience is being repeated, which is they just
So
don't get back.
is it going to require some communication from us to them?
Possibly. Staff can reach out again to the regulatory contact at Verizon. That's who we approached before.
Okay.
To get somebody from there, whoever in Verizon is in charge of their polls. But we can reach out to the regulatory contact at Verizon
Okay.
to make sure they're aware of this issue.
Okay, and and if you don't, let's say if you don't hear something in a week, let us know and we'll reach out. So.
Yes.
Okay. Okay. Next issue. Ms. Ferguson.
This is two parts. One is the government is being asked to indemnify Pepco for the actions of the government. We also have a separate issue about what type of actions, but the Pepco has a standard hold harmless and indemnification and insurance protections that they use for third-party attachers that are other businesses, whomever they've got on their pole. It's not other governments. And they, of course, have the poles in the rights-of-way of the municipalities. And so the municipalities had requested a fairly common thing that they agree to all the time because they insure it, and you can insure this, which is, as any business should do, is that there be joint insurance to cover, that everybody has insurance to cover anything that happens and any torts that happen, and also that the indemnifications go both ways. The municipalities, secondly, have requested to use language that I'm a municipal attorney for, I guess it's close on 40 years now. I have used hundreds of times with other governments, with other agencies, with private parties, and it's the standard language that we had placed in here that, subject to our immunities and specific provisions in the state law, that we would hold harmless for our negligent acts or willful acts or omissions, which is what municipal immunities have been waived for up to a certain amount of money. And so that's just a reflection of what the immunities do. We don't sign agreements that don't recognize that. It's not because we're trying to protect the municipality from contract damages. If there are contract damages, it's not having to do with that. It has to do with the case, actually, where a third party was involved, a farmer, and a tort happened. And because the municipality didn't put that limitation on there, there was a joint indemnification. The municipality didn't put the limitation on there. It was assumed to have taken the place of the farmer and therefore to be totally open to be sued for with no caps. So we always put that in there. And I tell my clients, you're not to sign this unless we recognize that there. I know that the lawyers in the group will say, well, those things are there one way or the other, but they're not. The phrase, to the extent allowed by law, our immunities are waivable. Municipalities can waive their immunities if they care to. And so we always put that in to make sure everybody knows that we're not waiving our immunities here by holding someone else harmless for something. And in fact, Pepco has run into this before, and so have the other utilities from which they took their agreements, because there's also language in there that says if you have caps, we get caps. And that comes from agreements they took from other jurisdictions. So it's clear that everybody's aware of the fact that there are immunities that want to be retained by the governments, and Pepco's claiming the same thing. Whether or not they can do that with a third party, I don't know, but that's going to be up to any third party they might damage. The other part is the argument here. There's no case law about it, and there's just a bald statement. It's bold too. That in fact, limiting the references that we have in this provision to negligent or willful acts or omissions is somehow limiting liability more than what our liability is already limited to. And that's not it. And I've had the same kind of language hundreds of times in agreements with everyone from the University of Maryland to Prince George's County to just private parties. We're just kind of referencing the fact as to what those immunities deal with. We're not immune from contracts. We're immune from unliquidated damages. That's where the immunities focus. And those are torts. So we are just asking for what we always ask for and have really never had much of an issue about. Mutuality of obligation, which I think is fair, and because we all have the same standards. They're listed, and those are the safety standards. So there should be mutuality of obligation here. We're on someone else's pole. Pepco points out we're on their pole. Yes, we are. And we're going to have insurance, and we're going to have to follow the rules. But we're on their pole, and they control everybody else. Municipalities don't. And so it's a sharing of liability in a much more fair way than, frankly, they've been sharing it with third parties who don't have a right to be on their pole. So those are the two items in this question.
Mr. Michael.
Yeah, so let me just start with the warranty issue and the no warranty and the waiver of warranty. If you look at section 12.2 of the agreement, it says subject to and without waiving common law and other governmental immunities. So we've already agreed to the language that says you're not waiving anything. So I'm perplexed by Ms. Ferguson's argument that in somehow they're waiving when we have an affirmative statement in there that says without waiving common law or other governmental immunities. And then what we do is we cite to the specific statutory sections that give the municipalities, and we don't argue about that, it's the law, and we're going to follow that. But what they want to do is add yet another step beyond their governmental immunities, and those governmental immunities already increase the risk to Pepco, because if it were a third-party attacher, we don't have any liability limits, and therefore, if there's a problem, we can get the whole amount of the liability. Here with a municipal, we are limited to a certain amount that we can recover. And the rest of the cost, again, would have to go to the customers. And so we're not wanting to put in this excess language that we don't know what it means or why it needs to be there. Secondly, the insurance provisions are designed to protect the pole owner from additional liabilities created by attachments that are owned by entities other than the pole owner. And she tries to make the distinction that they have a right to be on the pole and the other third-party attachers don't. That's not true. I mean, by FCC regulations, we have to allow folks to use our poles. But that's at the federal level. And these type, and as Ms. Ferguson said, this is the exact type of language that we have for other third-party attachers. And it's been agreed to hundreds of times. And so it is standard language, and there's no reason we should treat the municipalities different in this instance. So that's my spiel on that.
Mr. Greer.
Staff had no position on this item, sir.
Okay, any questions?
Yeah. So, so I understand the need to put in language to take care of issues where you've litigated, even if somebody else doesn't understand. So I guess from your perspective, even if you don't see the point of it, what's your? I need to try to understand what is causing you a problem with having this additional language.
Sure. What's causing us a problem is we've already agreed that they get the statutory immunities that they get, and all of their rights in terms of what they should or shouldn't get are completely set out in those statutes.
Okay, tell me how you're being harmed by this language. I guess that's what I'm. What is the thing? What are the municipalities taking away from Pepco that you would normally have if the language she's asking for wasn't included?
Because the additional language that they're asking to be added is not language that's included in the statutory immunities.
Oh, okay, and maybe we're just talking across each other. How is Pepco being harmed by having this additional language?
I'm going to let Mr. McGee talk to that.
That's
He's
fine.
the expert in this area.
You know, if I may,
Actually, if you're going to do that, I need you to come to the microphone so that the court reporter can pick you up. Yeah, that's
So thank you, Mr. Chairman, and in response to the commissioner's question, by the way, I'm Tom McGee with Keller and Heckman. So the language that was added, I think the utility is just fine with limiting the municipality's exposure to the extent that the legislature decided they should be limited. And in that respect, the limitation on exposure goes far beyond what somebody like Comcast would be, entitled to, or somebody, any other attaching entity that has statutory attachment rights
Well, that's
to
because
Pepco's
they're a
poles.
municipal system. So they are different. They are different in how they've been organized and how they are recognized by case law and statutory law. Municipal
Yes.
systems
No, that's
just have
exactly
they
right.
have immunities that others don't. I'm just really just trying to hone in on, even if you don't see the reason for it, I'm trying to understand why Pepco is concerned with adding this language.
Well, the language that's being added is not only the statutory immunity language. The language that we're objecting to is the language that says that municipalities aren't on the hook unless they're either negligent or willful. And that goes well beyond the limitations that appear in normal pole attachment agreements.
Right, but as Ms. Ferguson explained, municipal systems are very different than third-party entities. And if you can respond to her argument that she's concerned about waiving any of their traditional protections against lawsuits.
Well, let me see if I understand. Let me see if this responds to your question. If, for example, through no fault of the municipality, the attachment that is affixed to a potentially hazardous electric distribution system has a bolt that rusts, and somehow that fixture falls on energized conductors and someone gets electrocuted. The liability then becomes Pepco's liability, because even though none of this would have happened but for the attachment being up there, the municipality wasn't exactly negligent because it was the bolt that rusted.
Right.
Well, that's not the way third-party pole attachment agreements work. I mean, you're on the hook for what's up there on your pole.
No, I understand that. The difference is now you've got a new party on the pole. You didn't have a municipal system. You didn't have a governmental entity. They have immunities, and there are reasons for that. I mean, do you really want to have small municipal systems be on the hook for damages to the utility system? I mean, that's because that changes the way in which we think about immunities. It means just that's kind of the reality, is that you're taking on these new entities which hadn't been on your pole before. They were all private entities, but now you've got a governmental entity with immunities that are sort of part of what they are. The legislatures think that that's important, and so I mean, it sounds like you're asking municipal systems to waive their immunities by leaving off that language, unless I'm not understanding.
No, not at all, because the legislature has decided that municipalities should be off the hook for a certain number of, that there should be some limit to the exposure of these municipalities. We are only asking that the municipalities be liable for circumstances to the same extent that any other attaching entity is liable to, including the ones that the U.S. Congress thought have a right to be on Pepco's poles. And those liabilities do not extend to letting them off the hook because they weren't negligent. I mean, the fact that they're attaching fixtures to a pole distribution system that by its nature is inherently potentially hazardous is enough in obviously the pole owner's view, to be very careful about the exposure that the utility pole owner is subject to because of these attachments.
Okay, maybe I'm just not getting it. It seems like you are as a condition of their being on the pole, they are going to lose some of the immunities that they have now. They're not? Okay, so Ms. Ferguson, can you respond to that?
I'd be happy to.
Okay.
I have had trouble following this argument from a legal perspective for a long time, because I used to do personal injury work before I became a municipal lawyer. In the state of Maryland, you only have strict liability for a couple things. One of them's explosives. There's a couple, all right? Otherwise, to recover damages for something like the proposition that's just been made, something falling off a pole and knocking you, whatever it happens to be, all right? If Pepco owned that piece of equipment still, someone would have to show that they didn't maintain, that they did something, that they didn't do something they were supposed to do. There was an act or omission that they didn't make. Okay, so in the state of Maryland, that's what would be required for someone to be able to get damages. That's true across the board, municipalities included. Why does that change? It doesn't change once the municipality has it. Unless you can show some kind of act or omission that caused the event to happen, which then proximately caused the injury, there is no case. It is the same for Pepco as it is for us. And we're recognizing that because our liability has been waived for negligent and willful acts or omissions. And that's what we're recognizing. It's not a strict liability case. The fact that something falls off a pole doesn't mean that somebody gets to recover, no matter who owns the pole or who owns the equipment.
Yes, but if I may, you're envisioning a situation where Pepco is being sued because one of these streetlight attachments has fallen on energized conductor. Somebody got electrocuted. They're going to be suing the municipality as well, whereas this provision is a indemnification provision, so that the municipality is certainly free to make that defense that, well, it was no fault of our own, we weren't negligent, so you, injured person, you can't recover from us because we didn't do anything wrong. We weren't negligent. Fine, then there's no recovery in the lawsuit. The problem for the utility pole owner, that is managing a potentially hazardous electric distribution system, is that it has become convenient to put a bunch of stuff on this potentially hazardous electric distribution system, and that is increasing the liability to the utility pole owner just by the presence of all this stuff. And the indemnity provision is designed to protect the pole owner so that against all of these additional liabilities that they wouldn't be incurring but for all these attachments being up there.
Okay, so Ms. Ferguson, can you explain the exposure of your clients if the language were taken out?
And then, by the way, the language we're talking about is the willful and negligent language. That's all we're asking to be taken out.
Okay, so if you can,
You can imagine that we are extremely protective of the immunities, and any writing we have, we are extremely protective. The municipality, the sovereign, is not waiving the immunities for certain kinds of liabilities, such as intentional acts of employees. That's not waived, and you can't go after the municipality for that. For negligent acts and for willful acts, ones that are done intentionally but they're not done correctly, or it causes something to happen, it has been waived for that, which is why we refer to it. It's a limited universe of things that government has waived. The state has said we've waived our immunity. Otherwise, there would be none. I mean, we would not waive anything. This state requires this, and it just accurately states what the state has said the local governments must waive their immunities for. That's all this does. And the claim in Pepco's brief that we're trying to bootstrap onto some other immunity that we don't have is just false. It's just, we have it or we don't have it, we just don't want to waive it, and that's why we refer to it specifically as to what it is that's been waived.
Okay, and any response?
Yes, the language of the contract, it says subject to and without waiving common law and other governmental immunities and the provisions of several statutes.
If it's just duplicative, then please just humor us.
I don't know that it's duplicative.
Then-
I think it's additive, and I think it's suspicious. I think it's increasing Pepco, the pole owner's liability.
And
It's not beyond what the Maryland legislature decided was appropriate.
You have used that word suspicious before in conversations and in writing. I don't know what's suspicious about it. Like I said, I've used it hundreds of times. I've not had this argument before. If it's just duplicative, please just humor us. If it is not duplicative, I still haven't heard how it diminishes Pepco's protections.
Let me ask you this. Does Pepco have contracts with municipal and county governments on other issues? As a routine basis that you're aware of?
I would have to think about that. None that are coming up
Okay.
to my mind, Mr. Chairman. Doesn't mean we don't have them.
Right.
It just means I'm not aware.
So I guess the follow-up question would be, if in fact you do have other contracts with governmental entities, how's this issue been resolved in those situations? And if you want to get back to us, then go ahead. So, and I guess from your standpoint, I mean, are you aware of any contracts that your clients have with either Pepco or Verizon, other public utility entities, apart from this pole attachment situation? And how's this issue been dealt with in those situations?
I think the only time that we deal with Pepco in that respect is either through a contractor, and so that's separate. They're insuring separately.
All right, yeah.
Or a pole has to be replaced. I think there was one recently.
No, I'm actually talking about a broader
No.
pot
No.
of contracts, not just things related to poles and stuff like that.
No.
Okay, all right.
So do you have an existing O&M contract, your clients with Pepco for the streetlights? Is there something in place now?
No, it's because they own the lights.
Okay.
Okay, so you just,
So
yeah, okay.
Okay, so there's no contract in place for, okay.
Okay. Any questions from? Okay, so I guess we'll see what happens on this. Next issue, Ms. Ferguson.
I think we may be, let's see.
There,
Yeah.
there are two more.
Okay.
Yeah. Okay.
The notification issue
Right. Yeah, I'm there.
and then the termination.
Right, I'm there.
Okay.
Thank you. The notification, there is a reference, I think, in Pepco's initial brief that there are more issues here than actually are, and I think that might have been a small error. My understanding is that we have agreed that we don't have that last person off the pole gets to pay for everything provision anymore, so that's not an issue, because we're always last off, the streetlights are always last off the pole. So that's been resolved. The issue that's left here is, and this is again an operations-based issue, is when we have agreed that when Pepco has system requirements, that they notify us and that the municipalities will have to pay for their own relocations, because that's across the rate base and that's fine. But there's the issue of when a third party wants to attach or wants to do something so that the location on the pole may have to change, or the pole itself may have to change. That's happening with the installations of the small cells on the poles. So what Mr. Woodbury has reported is that notifications are made to engines, which is the acronym for the national kind of, I guess,
It's the National Joint Utilities Notification System.
but it's a national system. And he said that notifications that go there, if they go there, don't tell who's asking for the work to be done. And many times, the work that's being done is also done by a contractor of whomever's asking for the work to be done. Well, the municipalities have agreed that they'll pay for their own relocation costs for Pepco work. It's been agreed between the parties that the third party who's asking for the additional work should have to pay for everybody else to locate on the pole, or whatever expenses are involved with it. And I think that's a generally accepted principle. The problem is, from what Mr. Woodbury tells us, is it's extremely difficult to find out who's doing the work. And all we wanted in the agreement is that Pepco would tell us directly who is doing the work, so we know who to ask for payment from. We had originally asked that Pepco require them to pay us as part of agreeing to allow them to do this third-party work, They didn't want to do that. Said, you're on your own about that. So we said, okay, if we're willing to talk about that, we want to know, we want to be notified sufficiently in advance to know who it is that's asking for this work to be done so we can ask them to repay us. And we also want to know when the work's happening, because the other issue that Mr. Woodbury has reported is that the notifications don't come through and they find their street light hanging on an old pole somewhere and no longer functioning, and or maybe not any longer there. So that's what we're trying to avoid as an operational matter. We want to be able to be repaid for any relocations that have to be done, and we want to make sure that we're aware of people taking equipment, wanting to take equipment off the poles, so that we have enough time to get that equipment off the poles and also and safeguard it until it can go back up. Those are the two reasons. I don't think Pepco's changed its position that engines is going to be what they'll do or something like that. And that isn't enough for us based on what we understand from what's happening in other jurisdictions that use that system.
Sure, Mike.
So as you noted, page 18 of our brief, we talk about using the National Joint Utilities Notification System, or Alden 1. In Pepco, we use the Alden 1 system. And once the municipalities become a third party, an attacher to our poles, they would be placed into the Alden 1 system. The Alden 1 system will send notification if there's to be a change that there's going to be a ride out that has been scheduled for existing third-party attachers or the streetlight attachers, that there are new third-party attachment requests. The ride out identifies if the existing third-party attacher has to do make-ready work or relocate its facilities. Also, in that electronic notification, the existing third-party attacher, in this case it would be the streetlight attacher, is able to identify the new third-party attacher. And so the electronic system that Pepco uses provides that information. What the municipalities want is an extra step, an extra cost that requires Pepco to have one of its employees not only have it in the Alden 1 system, but to make calls to the municipality. And again, it's just another added cost that is not necessary, and the Alden 1 system deals with that. That's it.
I have a... Actually, sorry. Go ahead.
Yeah, how often do these episodes occur?
I don't know how frequent it is. 1 second, let me check with my...
Sure.
Your Honor, it would just depend on who wants to attach and why, and whether or not the new attachment requires a reconfiguration on the pole.
So does this happen frequently, infrequently? I don't need a precise number. I just need to have a feel.
I would say that it is probably an infrequent occurrence, but I haven't looked at any of the statistics.
Mhm.
But just knowing, like driving around where I live in Montgomery County, I don't see us reconfiguring poles that often.
Yeah.
And that's just,
Yeah.
living in the service territory.
Sure.
I don't see that happening.
Okay. Thank you.
And so the municipalities would be on this Alden 1 system,
Yes.
and then they would get a notice that some entity wants to change things, move on, and they would actually be told who that entity is.
Yes, and we would do a ride out, and if I get this wrong, my SME will tell me.
Okay.
What the ride out is Pepco, the third party attacher, and any other third party attachers who are notified can go out, ride out, drive out to the location,
Okay.
take a look at the pole, and see what the heck is happening.
Okay, so then...
And my understanding is, in the Alden 1 system, the existing third-party attacher or the streetlight attacher would be able to identify the new third party that is causing, the reconfiguration of the pole. In other words, in this case, the cost causer. And then the municipalities could go to Company X and say, Company X, you're causing us to expend money to move our streetlights, you need to reimburse us.
Okay, and then your concern is that they're not getting that information? Is that the,
There's a few. One is that the municipalities don't have any contractual relationship with anybody for this kind of information to be passed back and forth, so there's no enforcement mechanism if something isn't referenced in the agreement. What we want in the agreement, if Pepco contracts with a reliable service that gives out the information, that's fine, but saying that doesn't make that happen. We wanted something in the agreement that says that there is an obligation to do this. We can recognize that some third party may take on that obligation for them, but I also am not clear who puts in the information into Alden 1, and there's no requirement in the agreement that there be a write-out either.
okay, so Alden 1, you have to pay to be part of this, or is it free?
So Alden One is a software that we've purchased that you put the information into the software.
Okay, so can you provide that information to the municipal systems? Or would they have to?
Yeah, they
pay
would
for-
have access to the Alden One system once they become a streetlight attacher to our poles. They would be given a login. They would be told how they can access the system. I mean, these are not new systems. These are systems that we've been using for existing third-party
So
attachers.
could it be in the agreement that your clients will make a commitment to use the Alden One system to the extent that there is a problem with identifying a third party, you can contact Pepco and they'll provide you with the name.
I would need to know one more thing before saying yes to
Okay.
that, and that would be who puts the information into Alden 1, and is the municipality required to know to go look, or are we notified automatically as an inhabitor of the pole? Because if it's we have to know to go look, we're never going to know to go look.
Okay.
So you would get, my understanding is they would get an email notification once an attacher has put information into the system that they're moving, they being the municipalities.
Okay, so if you put that in the agreement that it's your understanding that an email notification will occur, and if it doesn't, then Pepco will notify, or you will take it upon yourself to notify if that's, I mean, I'm assuming you can make sure that the Alden One system does everything that you're asking that it do. So it notified, the third party comes in, they will notify the municipalities, provide the information, so then there's not going to be an issue.
I don't want to be being too picky here,
No,
but
that's fine.
since the third party is the one that is putting in the information, I don't know if Alden 1 automatically knows who to send it to, or if the third party has to tell them who to send it to, and how do they know who to send it to on the pole? I just don't know the answer to any of those things, so that the municipalities would actually be assured of getting the information that's being input by somebody they don't have a relationship with.
Okay, my understanding is that once the municipalities purchase their streetlight, they would register into the Alden system, and we would tell them how to get registered. And once you're in the system, you would get that notification.
Okay.
That's my understanding.
Well, so you could do a little bit of belts and suspenders. If you're a little bit concerned, maybe would you be okay if that's just included in the contract? That basically including in the contract what is already done. So it's not imposing any additional obligations on you, but it's giving your clients comfort that it's going to happen.
It's going to happen. That's
Okay.
that's
So
what we
Mr.
wanted.
McKeel, would that work for you?
Yeah, I need to just look at the language. It may already be in there.
Okay.
If you just bear with me, I'm getting to 18.3. Wrong section. I apologize. 8.7. I think, Your Honor, that's something we could consider. I have to take that back to my folks
Okay.
and make sure that the people who are running the Alden system, that I'm giving you the correct information. I think I am. I'm not.
And just a clarification for my sake, when you say they get registered for the system, I assume they would like tie it to a specific office in the county government or a specific official. I guess what I'm concerned about is some general message going from Alden to the municipality that just goes into the general inbox and then
Yeah,
nobody
no, I
looks
would
at it.
assume that there is, in the Alden system, when a user signs in, the email's supposed to go to somebody.
person.
And I would assume the municipality, maybe it's their director of public works,
Yeah.
or I don't know what you know what I mean? It would go to the director of public works. And they would be, yeah, they would pick that,
they would
exactly,
pick-
they would pick that person on who the notification should go to.
So is this similar to the 811 misutility process as far as notifications and that goes?
Similar, but I don't think it's exact.
But it's the same concept.
Yes,
Yeah, right.
Mr. Chairman, exactly the same concept. And, you know, engines and Alden One,
Okay.
they're ubiquitous across the industry
Okay.
and across the United States.
Okay. So all the current pole attachers are part of this system.
Yes.
Yeah.
Yes,
Okay.
that's my understanding.
Any other questions? Problem solved. Okay.
One more thing.
Oh,
Just to clarify, they're not going to have to pay to get their password and login ID and all that jazz, are they?
Nope.
Okay.
That's my understanding is no.
Okay.
We've purchased that system. They just have to get the training on how to enter it in and enter their information.
Okay.
Okay.
Yeah, and we're agreeable to say, we just want it referenced in the contract that that is an obligation, that you can use somebody else to fulfill that obligation, that actually does fulfill that obligation, and then that's fine. It's just, we don't have a contract with Alden One.
Yeah, I understand. Okay. So, next issue?
Okay, the next one is, we had a lot of conversations about under what circumstances could Pepco terminate the pole attachment agreement, because it's a street light and it is necessary to safety on the road, et cetera. And so I think we've gotten through most of that. However, the provision is agreed so far is if licensee fails to materially comply with any of the terms or conditions of the agreement or defaults in its obligations, or if licensee's facilities or attachments are maintained or used in violation, then we get 30 days notice and the opportunity to cure. And if it's not cured, then Pepco could end the agreement. However, then we got to the place of what if we don't agree that it's not cured? What if Pepco's being unreasonable about what it's requiring? What if the municipalities are being unreasonable about their position and they say, don't you dare touch that? And what we wanted was reassurance that we could come to the PSC for a resolution of that question instead of having to go to court about it. And I know the response on that has been from staff that they're not sure that there's jurisdiction for this and that the courts would be a better place to do that. However, having experienced the level of knowledge that is required to understand these agreements, we have thought that the complaint process would be much better because we would be coming in front of a body that actually understands what those requirements are and how they play out. So that was our request, to be able to be reassured that we could come to the PSC if there was a dispute that would lead to an action of termination by Pepco.
So, before anybody says anything else, for staff, so just educate me, and I guess probably the two other new commissioners, in those types of complaint procedures, who would the complaint come to within the commission?
Are you referencing like CAD or?
Yeah, that's what I'm trying to. So obviously CAD deals with, individual customers who have billing disputes and things like. So a complaint like this from either Pepco or a municipality, who would it be sent to? Would it be sent to the executive secretary, or I mean,
I'm
just
not
what's the whole process? And once it gets in this building, where's it go?
Yeah, I'm not exactly sure, but I think it would go to the commission itself. I imagine the complaint would be filed and be directed to the executive secretary and the commission.
Okay. So then at that point, but I'm imagining that some of this is going to be engineering type questions. So at some point, we would probably need some input or analysis by the staff engineering division about who's right, who's wrong before we make a decision.
Yes, Your Honor. I imagine that if a complaint was filed, it would lead to an evidentiary proceeding,
Okay.
whether that's in front of the commission or delegated to a public
Oh,
utility law
judge.
judge.
Yeah. Okay. All right. So apart from this question of whether or not we have the authority, the process is in place to handle this conceptually.
It is, yes, Your Honor.
Okay. Wait a minute. Okay, so any other? Well, go ahead, Mike.
I think I'm pretty much satisfied with what we've heard so far, but so it's just not, I guess the words that were kind of highlighted in the municipal reply brief was it's not traditionally been settled this way, but you're not saying it can't be
That's
settled by-
correct.
and
Staff
so-
would caution against opening the door to these types of contractual disputes. But I mean, it's something that traditionally the commission hasn't arbitrated. So I think, given the procedural history in this matter and the fact that the commission will ultimately be approving a template pole attachment agreement or template sales agreement, opens the door to being able to hear these disputes.
You're answering my next question. Yeah, okay, it sounds like we're there, and if I understand correctly, both of the parties are requesting that we play that role. Is that your staff
That is,
understanding?
yes, Your Honor.
Okay.
Is that,
all right.
Okay,
so that's
so,
true
so
of
Pepco is also asking.
Well, I think, how do I say this? I think we agreed with staff's position in its initial brief that this is, at the end of the day, a contractual matter, and the more appropriate place to deal with contractual issues and interpretation of the contract is at the circuit court.
I'm a little
Can I-
concerned about
Yeah, can I just finish-
enforcement. So
I just
I
wanna
mean,
finish my
before we
question
even,
first.
yeah.
Yeah, but can I just, it was referenced, what you said to the legislature, and under the context of, you told the legislature that the commission could play this role and had the authority to play this role.
Sure.
I just would like that understanding.
Sure. So what we told the legislature was that the determination of the model contract and the model purchase agreement was before this commission, and that would be approved. I don't think we said that contractual disputes should be resolved, but if the commission wants to take that on, they can take that on.
Okay, thank you.
So I haven't really even looked or thought about this issue, but I guess, from the municipal perspective, you guys should be careful what you wish for. But separate and apart from that, I mean, it's making determinations and making those determinations enforceable. And I don't know that the commission. I mean, I'm brand new. This is like my second week, so so I don't know that the commission has. And I guess I can ask staff that. Does the commission have mechanisms in place to enforce judgments that they make? And it could be, the judgments could be specific performance, or it could be monetary judgments. This opens the door for a lot of different. I think maybe this should come off the table and be dealt with. I mean, I understand that you want to resolve all of your issues. This one gives me real heartburn because I don't know that necessarily your clients would benefit from this, and it also makes me nervous about. I mean, separate and apart from whether this is jurisdictional. I mean, you were concerned about waiving liability before, and you're going to be waiving a different set of issues coming before us. I mean, will your clients be comfortable if we say, bad job, $1 million penalties? I mean, which I don't know that we even have authority to do that, but I don't think your clients would necessarily want that.
That is not what the request is, though. This is a limited request. And it is for if the municipalities seek the ability to apply to the commission to resolve disputes if needed, once Pepco notifies them of an intention to terminate, and seek confirmation from the commission that this route is available. So if at some point Pepco says, we're going to terminate this agreement and you get off the pole in the next 30 days, that's the situation in which
No,
we would like
I
to
understand
tell
what you're
it.
saying, but I like to spin things to go as far as possible. So, so the argument from Pepco is that you've been recalcitrant and you haven't done the things that you need to do, and the lights are falling down. And then it can kind of go back and forth, and then the commission is in the position of trying to figure out or cobble together what authority we have to resolve the matter. I think I'd really like to see, hi Bob. I think I'd probably want to see a legal analysis about what authorities we have. I mean, separate and apart from whether this is a good idea or not, I just don't know that we're in a position to do something like this. And so if we're not, it's probably better to not put this into something that then becomes unenforceable.
So one question, what's the current process for the people that are currently on the polls? So if there's a dispute between you and Verizon or you and Comcast, I mean, how does this get resolved now?
If I may. With FCC regulation, if there is a dispute, Comcast believes that Pepco rates, terms, and conditions of pole attachment are unreasonable, it would go to the Federal Communications Commission.
Okay.
If the issue were simply an issue of enforcement of the contract, the FCC recognizes those type disputes should go to the courts.
I see.
Well, and if you end up with a challenge with Pepco and Verizon, then do you have a jurisdictional issue between us and the FCC? I mean, I'm just getting a little bit nervous about because if you end up with a dispute with that ends up being a dispute with both Verizon and Pepco, and I guess Pepco lawyer can respond to that. Does the FCC then start to get into the matter?
Because of the type of arrangement that we have, it's only about streetlights. I would be surprised if the FCC would ever be involved in something like that.
Well,
or the
but
FCC.
it's pole attachment,
Yeah.
so it's really anything that's on the
Yeah.
pole, and
Who
so
owns
you could have a lighting issue where the lights keep falling down on somebody's, something that FCC is jurisdictional to, and then so I'm trying to spin it out because this is new, and
Where does that go now? If a streetlight falls on somebody,
what if a streetlight falls on something that's jurisdictional to the FCC?
Well, let me just clarify one thing, Commissioner, if I may, is that the FCC would have no jurisdiction over the attachments made by a municipality to Pepco's poles.
Yeah.
And the reason is because municipalities do not qualify as one of the two entities that has federal pole
No,
attachment
but
rights.
what I'm asking is, what if you end up with a situation with Pepco, a municipality, and an entity that's jurisdictional to the FCC?
Then it potentially gets complicated.
Yeah, that's what I'm worried about.
Can I just add?
Sure.
My understanding is this commission has authority to issue fines pursuant to its statute for things, but it doesn't have authority to necessarily enforce contracts like specific performance
I'm worried about
or
that,
to issue monetary judgments or anything like that. That's beyond the authority. Now, I haven't done a thorough analysis, but I've been doing this for 30 years,
Sure.
and that's my understanding.
Okay, that's helpful, thank you.
All right, so I guess bottom line is we'll just have to check and see what, I mean, if we can do it and we decide we want to do it, apparently there's a process in place for us to do it, but we need answers to those first two questions. So.
It's possible to go to the Attorney General's office and ask for opinion too, I guess. That would be one of the,
We'll check into that. Okay. So is that it?
I think that is it.
Okay.
Mr. Chairman?
Sure.
I'd like to, getting greedy here. You know that request I made about investments and depreciation? I've been thinking, tossing it around in my head. I think what would also be useful for me would be how much, at this present moment, what the undepreciated balance of the light fixtures are, as well. So
the undepreciated balance of the light fixtures in our account 373, which is street lighting.
yeah, that's
Yes.
right.
And that would be all 66,000, is that the?
Yeah.
Okay.
Yes, I believe that would- okay.
Yes, I would like it to be of everything. My suspicion is that you're on the general ledger of your company, you've got those numbers. Hey, if you can go back further than 15 years, that would be nice. I mean, I don't know when you shred up your stuff. I know the federal government only requires you to keep it for 7 years, but
No, I can get you. Feel very certain that I can get you what is in account 373.
yeah.
The undepreciated balance of those amounts that are placed in the streetlight account, the
Yeah.
FERC streetlight account. I feel pretty confident
Okay.
I can get those. So I will get those along with how much was invested in the streetlight
Right.
and how much depreciation in the streetlights for 15 years.
Yeah, if you can go back further than that, that would be great. But I don't want to be too obnoxious here.
Okay, so here, can I see that? I've just been told we have that number. It's,
No, I wanted it for each year. Just email it to us.
no, the total, I will, but
Oh.
the total in 373,
Uh-huh.
right now, the undepreciated balance is $14,031,746.
Say that again.
$14,031,746.
Okay, and I'm going to get a little bit greedier still.
As of April.
Okay, and well, then I'm going to even go down further. Is it possible then to take the municipalities that are present here and give us the undepreciated for those systems? No. Okay.
I would be thoroughly surprised if they could do that.
Well, I thought I'd give it a try.
We can't because we keep it by mass plan.
Yeah.
Right, yeah.
Let me,
Yeah.
I know that answer too, even
Yeah,
though
no,
I'm
I
not
thought I'd
accountant.
give it a shot.
No, I mean, look, if you, I mean, I was afraid to ask going back 30 years, but if they can look in their ledger and go back that far, I can get you an average life of light pole calculation.
Yes, you can calculate averages like that. I can get you a lot of averages, a lot of different things.
Okay, all right, well,
So,
thank you, Mr. Chairman.
just to wrap up here, the requests that have been made of various parties, I guess what I need is some expectation about how soon you can get something to us. I don't want to put you under the gun, but just tell me truthfully, how long it'll take.
So we are happy to talk with the municipalities about the 2-year warranty issue
Okay.
and try to work through that to,
Okay.
I guess, take off the table the as is, where is. Is that your understanding, Sue Ellen? That's what we're going for. I do have a couple key people out of the office on vacation
Sure.
this week, so that's why they couldn't be here. Thinking of Lance Schaefer, who does a lot of this work for us. So I wouldn't think it would be more than 2 or 3 weeks, Your Honor.
Okay. All right.
I don't know what what Ms. Ferguson's schedule looks like. I know she's very busy.
I'm away the first week of August.
Oh yeah,
So,
so am I.
Add
Sorry.
that in.
So this is, today's
So
the
that-
13th.
It's the 13th now.
take my son to college for orientation.
Yeah, you can't miss that.
Yeah, no.
It's 2 weeks and a day to the end of the month, pretty much, or to the 31st, actually. There's a little bit more time in there. I think there's also wording that we needed for the record keeping in terms of the changes that people want to make on the polls and getting notice. So you need some wording for that too. So there's 2 wording issues.
So if we
right.
said August 18th, does that work?
Oh, certainly.
Okay.
I think we can make that work. Yes.
Okay. All right. And as we said at the outset, I mean, we're taking all of this under advisement, and we'll be issuing. Well, this is just for them to get the information to us, not for us to do anything. So we won't do anything before August 18th. So.
And I will endeavor to get those bench data requests back as quickly as possible.
Yep.
I won't dally with those.
Well, and then the sort of the more sort of problematic question about whether you have an alternative to the mass plant valuation. And I understand that that's not something that you're going to be able to resolve by the middle of August. But if you can at least start to noodle that and work with Ms. Ferguson to see if there is a different way of getting to that valuation.
Yeah, I am sure that my subject matter experts will have some ideas. Whether they're workable or not, I don't know. But
Okay.
Sure.
we will have
Take a shot.
ideas and work in good faith to try to bridge that gap like we've done on all of these issues. And so have the municipalities. Let me be fair.
Understood.
Yeah, but just to add so you understand the importance, that's important to me as well, that we come up with an alternative to mass plans. So I think we want to find something that's workable for the municipalities. So,
Message received loud and clear.
okay.
Okay. Thank you. And with that, we are adjourned.